Good morning, Ms. Avi.
Good morning, CJ.
How are you?
I'm okay, thank you, CJ, and I trust you are too, and
No,
the rest of the
we
commissioners.
are. We are, thank you. Oh, first, let me just welcome the Judge President of the Labour Courts, JP Mulahlehi, and his team from Netluck, Messrs. Twala and Mkalipi. Good morning, gentlemen. You were here not so long ago.
Yes, CJ.
We have a transcript of that long interview in front of us, so I don't imagine that we will be particularly long with you, if at all. But unless you've done something really bad since we were last year, that would have to raise with you, which I doubt.
I have not, CJ.
Yeah. You are the one-time engineer turned trade unionist turned advocate
That's correct, CJ.
who studied a BSc engineering at Wits, then some years later went on to obtain an LLB cum laude, and then an LLM with distinction.
I thought, if I may, I might explain, as I didn't last time,
Yes,
that rather
please.
unusual pathway. It was really rooted in early experience, accompanying my father from a very early age, who rejected segregation and crossed apartheid's boundaries to work with youth and artists in Soweto and Alexandra. So from the time that I was about 8 or 9 years old, I was accompanying him in those spaces, accompanying him to classes, meetings, poetry readings, and so on. And as a result of that experience as a young person, it became clear to me how artificial the segregated environment of my schooling was, and the artificial environment that other white South Africans were being forced to grow up in. And as a result of that, I made a decision to leave school early. In those days, it was possible to do Standard 9 and Standard 10 in 1 year, so I rolled them in when I was 17. And the one thing that I felt was lacking in my education was the ability to speak an African language, because that seemed to be the last barrier between me and everybody else in our country. So I then went to Botswana in order to immerse myself in a Setswana-speaking environment. It's not an easy language to learn when you are English speaking, because it doesn't just map easily onto English the way another European language might, like French or Italian. And so an immersion in a completely Setswana-speaking environment where nobody could fall back on English was necessary. And while I was there, I joined the ANC in exile. And when I returned to South Africa, the reason that I did the engineering degree was that that was something that the ANC thought would be useful in a future liberated South Africa. But by the time I finished that degree, Chief Justice, we were in the state of emergency. It was 1986. And so after completing my apprenticeship, just to complete the qualification in 1987, Chief Justice, I then went to work for the trade union movement, which at the time was, as you will recall, really the only legal activist form of organization in South Africa. And my earlier experience with working in Botswana and learning basic proficiency in Setswana obviously supported that work, because I was then able to properly communicate with and properly represent workers in the two unions that I worked for, being SACAWU and then the National Union of Metal Workers. So I know a lot of people ask me, how did you move from engineering to law? And that really is the answer. After 94, I then joined the CCMA because I'd had a legal experience, although really paralegal experience without a formal legal training. I'd had that experience representing workers at the industrial courts and in various tribunals. And when they recruited commissioners for the CCMA, they drew us from the ranks of trade unionists, qualified lawyers, and then also a lot of people who had come off the Truth and Reconciliation Commission. So that then explains the pathway, which might otherwise look rather strange.
All right. So you've been a member of the KBA since 2010.
Yes, I think I did pupillage in 2010, Chief Justice. So I think I only became a member at the end of that year.
All right. And you remember of Saslo, panelist of Tokiso, and an arbitrator. Are you an arbitrator, or what is a fellow of the Association of Arbitrators?
It's just an accreditation, really.
Oh, I see.
So I was always an accredited CCMA and Bargaining Council arbitrator, CCMA accredited, but I wanted to expand into commercial arbitration as well, and that requires one to do a course and then to join the association of whatever it was, arbitrators. That wasn't very long lasting. I only did one commercial arbitration, and after that, I allowed my membership to lapse because I became more and more drawn in the labor law direction in my practice.
Your practice is mostly focused on labor law.
It is, yes.
And you appear a lot in the labor courts, and you've appeared in big cases, as I understand it, in the Constitutional Court as well.
I've been lucky enough to appear in 2 of those, yes, CJ.
Which ones?
That was the assigned services case and the Dunlop mixing case. The first one to do with the interpretation of Section 198 of the LRA, which deemed precarious labor broker workers to be employed by clients after 3 months. It was the interpretation of that section, which was a new section. And in fact, that was very important to me because as a CCMA commissioner, I had found myself unable properly to reinstate unfairly dismissed workers who had been placed through labor brokers because the then Section 198 provided that they were employed by the broker and not the client. And the brokers would then say that they couldn't place the worker back at the client. I had a very a sort of wake up when I had a case of a hotel worker who was dismissed for theft. And there was no proof that any theft had taken place other than the guests say so, that he had left something in his room. And she was dismissed merely because she was the cleaner attached to that room. But when it came to applying the primary remedy of reinstatement, the broker explained to me that it couldn't put her back at that hotel, and in fact she would be blacklisted, and so they couldn't use her at any hotel, and therefore that they couldn't reinstate her. And that then brought the unconstitutionality of that section to my attention, and that became the subject of my LLM thesis, the unconstitutionality of that section. That essay won the Ishmael Mohammed Law Reform Essay Prize, and a few years later the law was amended in the way that we all know. But then the interpretation of that amendment was challenged, hence my arguing that assigned services case. And the Dunlop case, as this forum knows, was the one which dealt with derivative misconduct.
The last time you were here, you had acted at the labor court for only, was it 7 weeks?
It was 7 weeks, Chief Justice.
Just remind me, had you had time to write judgments?
I had, Chief
for the
Justice,
court?
at the time, I believe I had 35 written judgments and I think 3 extempores. But since then, I've had the opportunity to act for a
For
further...
how long?
I acted for a further 2 weeks in the 3rd term in the Labour Court in July and August. I also acted for a week in the Western Cape High Court, and I've now been appointed to act for the whole of the 4th term in the Labour Court. So I'm at the end of the first week of the 4th term. I think if we add them all up, that comes to, I think it's 11 weeks now, Chief Justice, and by the end of this term, it will be 19 weeks.
All right. And have you produced any further written judgments during this fresh stint?
And in fact, I realized yesterday when I was going through my judgments that I hadn't provided any of the more recent ones. So I emailed them through. I know it was very late. But I've produced, since my last sitting here, another 5 written judgments. In fact, it's 6 with the High Court judgment. And I've given, I think this week, I've given 3 extempore judgments and 1 written judgment, Chief Justice. Right now, I'm sitting with 4 reserved judgments, including one from yesterday.
All right. In addition to being a prolific judgment writer, you have written outside your short judicial career. You've written an essay that was published in the SALJ.
Chief Justice, that was the essay I was referring to on the constitutionality of
Oh, I
Section
thought that
198.
was. Oh, okay.
Yes.
So it was. Oh, your thesis became the article. Oh, I
Yes.
see.
Yes,
Okay.
it did.
All right.
I
And
don't have a lot of academic writings to my name, CJ, as you will see from the questionnaire and
Yes.
the CV. Aside from written judgments and many, many arbitration awards that I've obviously written over the 25 years of being a CCMA commissioner, my only other written work has been contributions to conferences and training sessions. And something I realized when I was going through my papers just in the last 2 or 3 weeks that I haven't even put in my CV was that I made a presentation to a language conference in 1993, one of the many language conferences that was leading up to hopefully establishing a language policy for South Africa post-democracy. And so I argued in that conference paper, as I would today, that English should not be privileged as the primary language either in the country or in the courts. I think we spoke a little bit about that last time I was here, Chief Justice, and I believe that since then, you yourself have suggested that the rule about English being the language of courts may well need to be revisited.
all right. You've also been a guest lecturer in the master's program at the University of Cape Town.
Just from time to time, yes.
From time to
CJ.
time, yes. And you train pupils. You've trained pupils, and what's that about recruiting, training, and supporting youth for placement abroad?
Oh, that was in Canada. I was very close to my extended family, and when my father emigrated to Canada in 1997, I followed him with my family, but I couldn't get used to life there, and so I returned. But while I was there, I was working with an organization that was supporting media freedom in the Pacific Rim, and that entailed recruiting and training youth interns. But that was mainly in the area of media studies. In terms of other training, I think my most prolific training has been for the CCMA. I trained several cohorts of new commissioners, which I felt was very important because CCMA commissioners, especially in the early days, were really in a position to deliver, I think what this forum last time I was here named transformative justice. So I've trained a number of those cohorts of commissioners. I've also worked training paralegals and community advice officers and young attorneys in the legal NGOs. And at the bar, I trained as an advocacy trainer and served as a member of faculty training pupils in the method, as well as one pupil who was allocated to me. And more recently, I've worked with juniors, mentoring juniors, both on a co-briefing and a fee-sharing basis. And Chief Justice, since I was last here, I've relocated to Johannesburg. I'm now a member of the Johannesburg Bar. I'm a member of the Maisels group, which has recently established a pro bono initiative which links young advocates with pro bono work. And my role in that initiative now is to assist by mentoring young advocates who take up pro bono cases, because of course, people who need pro bono assistance need that assistance to be at a high level of quality. And I think one of the aims of the pro bono project is to ensure that advocates are mentored by people with experience in the particular area of law that they're going to be working in, both for training purposes and to make sure that litigants needing pro bono assistance are well represented.
All right. As I recall, no one had a real quibble with your credentials the last time you were here. Only two issues had been raised. One by the BLA that questioned your commitment to the transformation of our society, which I found bizarre. considering that your background as a trade unionist, having worked for years with NUMSA, SACAU, NUM, all those trade unions, your work with young people, and the other good things you've done. Um, but then they've turned around and actually support your candidacy. So
Yes, I noticed
all's
that.
well that ends well. But then there had also been this issue that you had only acted for a very brief spell and could perhaps benefit from a longer acting stint, which now seems to have been addressed. But let's see.
Yes.
I will stop here, Ms. Ravi, and hand over to JP Mulatlegi to put any
Thank you.
questions he might have for
Thank
you.
you.
Thank you very much, and
What did I
good
call it?
morning, Chief Justice,
No, I
and
didn't.
Good morning, Jay.
good morning, Commissioners. Good morning, Ms. Harvey.
Morning, JP.
I don't have many questions for you, but just maybe let me start with the language issue. I think there's consensus that there's a need to bring all other languages to the same level as English. But shouldn't we be doing the very basics, trying to walk processes like in the court, especially in the labor court, the majority of our users are lay litigants. And they come there speaking Tswana. You speak Setswana quite fluently. Now, if they address you, should they be saying my lady? Which is a concept that I find even those who speak English sometimes struggle with. They refer to our women judges as my lord, and then they correct themselves, my lady. Isn't that something that we should look at? Because sitting in the labor court, I always find people who speak Zulu, for example, they'll be saying, Mhlali wa Kantoro. And you have an advocate who speaks Zulu, who's Zulu. Shouldn't we be encouraging that as a kind of a symbolism that this language is also as important as any other language?
Yes, I would totally agree with that. Are you saying that one could bring in certain phrases in all South African languages whilst still maintaining English as the main language of record?
Yes.
If you're suggesting that, I would certainly support it because, as you say, the concept of my lord and my lady, they're very much English concepts, English as in the UK. So I also find it very strange. I very much like the fact that in the Constitutional Court we refer to judges as justice. That seems to describe their position better. But yes, bringing in those linguistic changes would certainly be a first step.
Yes, thank you. And you are currently acting at the labor court now,
Yes,
and you doing urgent court this week.
this week I've been on urgent court, yes.
And our urgent court is on for 24 hours. The
Yes.
last time I checked, yesterday before I left, there was a restraint that came in. How did you manage to deal with it? How are we dealing with those cases that are supposed to be continuing this morning?
Well, the cases on my roll that are supposed to be continuing this morning have been reallocated. The acting DJP very kindly intervened on my behalf and took those cases and reallocated them to somebody else. So that's how that's been handled.
Yes,
in terms of just dealing with cases coming in at the last minute, it's important that people have access and that they be heard. The fact that things come in now on case lines means that one has to wait for the matter to pull through. I had a case like that, I think it was on Wednesday, where it literally only pulled through about an hour before court was to commence. And I had to just stand that case down for 2 hours in order to read the papers. But I think that the court online system is helping because it's all there online and everybody can access it through their own device. And certainly on urgent court, one just does one's best to read and to hear and to hopefully to resolve the issue as fast as possible.
Yes, it's actually the senior judge, not the ADJP, that agreed to take over your matters. But it's quite important for the commissioners to also understand how things are working at the labor court. They're always concerned that court must function effectively, continuously, and the working between the judges Where was this issue discussed about the senior judge coming in? And I know that even Thursday, I just overheard it as I walked into some room that somebody else was going to take over your matters.
Yes, JP, that is in the tea room. And we discussed the tea room last time I was here. I have been attending the tea room every single day. And as you pointed out to me, Judge President, it's an invaluable step to take because it puts you in touch with other judges. You can discuss your matters with them. And as you've just pointed out, matters can be reallocated and shared. In fact, there was a case on my urgent roll on Wednesday, which I was ready to deal with. But when I arrived in court and looked at the service affidavit, I realized that service hadn't been properly effected. And I was able, instead of removing the matter from the roll completely, I was able to find another judge who was able to deal with it the next day, pending proper provision of that service affidavit. And that wouldn't have been possible without the tea room collegiality in the Johannesburg court.
Thank you very much. The other thing you spoke about training. I'm sure you're aware that we're now relying quite heavily, unfortunately, on pro bono. Thanks to the willingness to support from the profession. Now, some of the profession has asked us to, particularly the bar societies have asked us to do training. Is there something that you think you could contribute, and what is your view about us as judges going there and putting aside a weekend to go and conduct those trainings? And also, what is your view about us training also in the CCMA?
I think it's absolutely essential, Judge President. Obviously, it would be ideal to have mostly permanent judges and for there to be pro bono and acting judges only for the purposes of filling in gaps and I suppose for sort of pipeline for training potential future judges. But at the moment, given the backlog and the amount of pressure on the labor courts, I support the initiative to invite as many acting and pro bono judges as possible. And then, of course, it becomes especially important to train and support those judges. In fact, a pro bono judge was allocated to the double chambers that I'm in at the moment, and he approached me for assistance on a few occasions. And weekend training, even better than approaching a judge at 9 o'clock in the morning while they're preparing for their own matters. I think that's important. Personally, I love training. I enjoyed it when I worked for the CCMA. I've enjoyed it working for the legal NGOs. I would be happy to give weekends to training, although maybe I shouldn't speak too soon, given the judgment load. And then you mentioned CCMA training. I think that's also very important. You know, when we first established the CCMA, that first cohort of commissioners received extensive training in the new Labour Relations Act. And I think the quality and the standard was very high. And because we were all pulled from trade unions and the TRC and people who were active in the labour movement space at the time, I think we all really understood the constitutional project of the LRA. And I think that has been watered down over the years. And there are now people in the CCMA who have diplomas, but possibly not the social context clear in their backgrounds. And that was something that I worked on a lot when I trained CCMA commissioners as a commissioner myself. And I wonder sometimes whether the review judgments of the labour courts are intensively revised with CCMA commissioners, and I think that would be an invaluable contribution to the quality of awards coming up. And the better the awards from the CCMA, JP, the fewer reviews will be brought to our court and the lesser the backlog should get.
Yes. You attended the wellness seminar, which was done at lunchtime.
Yes, JP.
And I'm sure you suddenly heard the horrors of the workload of the labor court. What's your view on that? Especially that if I may remind you that at one stage you had a big matter to deal with, and I walked into your chamber and said, I've got a file here that I wouldn't want it to be postponed. This person comes from far. What, what would you say to that approach?
I remember having that very large, I think it was an ESCOM matter, JP, which required a lot of reading. And you came and asked me to do a leave to appeal. And I think I said to you I wouldn't have capacity to deal with it until the next week. But yes, there is a huge workload, JP, and I think that's why that wellness seminar was held. As an advocate, I think I have already learned how to manage my time and how to manage my personal wellness in exactly the ways that were being discussed. Taking down time, making sure that one remains physically healthy, exercising, going through stress reduction techniques. But one also needs to develop a clear discipline when it comes to being prepared and to producing judgments. And I think that I have been thinking about this, about how I will manage the workload if I am appointed. And one of the most important things, I think, apart from being prepared and working hard, are doing judgments quickly. I certainly found as a CCMA commissioner and also as an acting judge that the longer the period that elapses between the hearing and the writing of the judgment, the more difficult it is to write the judgment. As CCMA commissioners, we were required to produce awards within 10 days. And although that put a lot of pressure on us, I think it really helped to support the quality of decision making. And as an acting judge, I think that if possible, I will try to hand down judgments as immediately as possible, because I really have discovered that the longer that I leave it, the more difficult the decision-making process becomes.
I'm not going to ask you about your judgment writing, something that I need to sit down with you to share with us as to how you managed to get your judgment so quickly out. But let me ask you also this, and probably to relate to it. Have you attended the lunch seminar which the acting judge president Mahalelo keeps throwing at us almost every week? I find it so heavy burdening. What's your view there? Have you attended it, and what do you think the value of that is, if you have?
Sorry, which seminar is that, JP?
The lunchtime seminar. Not so long ago, she had arranged for, or you probably were still not yet acting, but she arranges regular seminars on various topics. Recently, it was a whole issue about the restraint of trade and agent application, because our rules very difficult to apply in as far as restraint are concerned. That's my view. Other judges hold a different view.
I haven't heard about those lunchtime seminars.
Okay.
I would really welcome them. As a SASLAW member, I've often said that we're lucky to be labor lawyers in an environment where there are frequent workshops and updates on the law, because otherwise, as a practitioner, you only update yourself on the specific cases that you're handling at the time. So regular updates on case law and the proper approaches to different types of disputes, I think, would be invaluable.
Yes. The last question for me, Chief Justice. Last time you did indicate that you're quite happy to travel because the Labour Court judges travels across the country. But now we're working on actually trying to establish a footprint in each of the provinces. You realize that the traveling may actually be extended. If you're in Cape Town, we're likely to send you to George. We're likely to send you to Mafikeng in Northwest, and Limpopo we already established fairly. We're not yet satisfied that we're fully operational, but there's a regular attendance at that, in that province.
Yes, JP, I think I mentioned last time that I am happy to travel. I am now based in Johannesburg. I live here now. This is my home. If I'm asked to act in other centres, I will enjoy it. And I think I mentioned last time that when the CCMA also used to send us around the country, I really enjoyed it because the personality of the types of disputes that come before forums in different parts of the country are different. And that is always entertaining and engaging and interesting, and I do like that.
Thank you, Chief Justice.
Chief Justice. We're fine.
Thank you, CJ. Ms. Harvey, my question is a non-qualification question, rather benign, not like the tea room attendance one last time. But you stated in your introduction that you'd spent some time with the ANC in exile and you'd had discussions with them about your tertiary education qualifications. But in your application, where it says, please furnish particulars for your membership of any political organization, past and present, you've said none and not applicable.
I suppose I didn't consider myself officially a member because the ANC was a banned organization at the time. That's the best answer I can give to that.
And maybe you should have said something about it, but it's something that we raised with you on the last occasion, and you explained your involvement fully. It is in the transcript. Was that the only question? All right. Commissioner Hassan?
Thank you, Chief Justice. Ms. Harvey, thank you for coming back to the JSC. My question is a little bit more around the future and what it might look like. We're entering a world in which algorithms now have the ability, and in some instances are hiring, they're monitoring, and they can even dismiss workers. And the traditional concepts of employer, employee, and even a workplace has been quite stretched by these different AI-driven platforms, and even remote working and remote labor. So from a judicial perspective, how do you think South African labor law should potentially evolve to protect fairness and dignity in this changing world of work, but at the same time not stifling innovation and what could come from that? Thank you.
Thank you, Commissioner. The guiding principle is in the Constitution, and it promises fair labor practices to everybody. That said, the world of work is changing. As you mentioned, I think you mentioned AI. There's also a lot of gig economy work and more precarious or non-standard employment. And it's becoming apparent that the LRA, which was designed in 94, 95, it presumed a number of things. It presumed, for instance, long-term, stable, career-based employment. And it also presumed a strong trade union movement which could advocate for and protect the rights of employees. And what we found now is that our labor law is to some extent becoming misaligned with the realities. The trade union movement has diminished, it is less strong, and I think that is, at least in part, if not wholly, because of the changing nature of work. Trade unions, which had traditionally structured themselves around the permanence of work, the fact that there could be full-time shop stewards, people who could be trained, who would stay in workplaces, the outsourcing of work, the platform nature of work, all of that has undermined and weakened the traditional way in which trade unions have organized. And I think that alternative forms of worker organization are inevitably going to emerge, and our law is going to have to adapt to accommodate them, because workers need to collectivize in order to enforce those rights to fair labor practices. As you may well know, I've worked on one such case, the Simunia Workers Forum case. And a few years ago also, I worked on the first Uber case, which was brought, in which the question was whether or not Uber drivers were employees. That iteration of the Uber case kind of fell through on a territorial jurisdiction point, which was a pity. But I believe that a new challenge is being brought, and that's going to mirror these developments around the world. So I think that our law is going to have to develop in response, and I hope that it doesn't lag too much behind. I think at the moment it is lagging a bit, and we all know that law reform takes time, but those things are definitely going to need to be addressed. Otherwise, we're going to find a complete disconnect between the world of work that South Africans are in and the legal framework that judges are applying.
Can I make a
Commissioner
follow-up? Can I
Marmafai?
make a follow-up, CJ? Thank you.
Yes.
Thank you, CJ. Good morning, Advocate.
Good morning, Commissioner.
Just on the point that you raised around the diminishing of the strength of trade unions or trade unionism, do you think that the alliance that the unions has forged, as an example, citing the alliance that COSATU has forged with the ruling party, could be an obstacle to the maximum one country, one federation? And do you think that there has to be a relook at that? But at the back of our mind, take into account the fact that the distinguishing factor between, let's say, between SACTU and other unions was their belief that before you are a member of a union, you are a member of your own community. So therefore, you can't just restrict yourself to shop floor issues. You have to address the issue of the bread and butter issues of your own community. Thank you.
I'm not sure that I'm following the question, but to the extent that you're looking at the tripartite alliance, I think that I don't know whether the alliance between unions and political parties is what has contributed to the weakening of it. I actually do think that the changing nature of work is what has done that. And right now we're sitting in a situation where I believe the latest statistics are less than a fifth of South African workers are unionized at all. And in a situation like that, it becomes less and less relevant, I suppose, what the federations do.
Commissioner Marmafai?
Thank you. Thank you, CJ.
Thank you very much, CJ. Good morning, Advocate Harvey.
Morning, Prof.
It appears to me, I'm not sure if I'm correct, that there are violations of labor rights in the agricultural sector. And farm workers are arguably the most vulnerable because they face evictions, casualization, and exploitation, and all those goes to the fact that they are employed in these farms. There are several legislation in South Africa that tries to deal with labor rights: LRA, BCA, QUEDA, SDA, and various pension legislation, and the constitution on top of that. I'm just wondering, what is your view, if any, on this fragmented legal regulation of employment in South Africa, and whether it is adequate in addressing challenges that are faced by farm workers in this country? And in addition to that, do we need activist judges who really understand the plight of farm workers in this country? And I'm asking that based on your background, of course. Thank you very much.
Thank you. Definitely, the law is not reaching. We need fairness. We need fair laws, but we also need fair reach. And it's not just farm workers, but they are a big part of the precarious mass of workers. It's also precarious industrial workers, non-standard workers, and in many instances, with both farm workers and precarious industrial workers, it's women workers who really cannot access the vast raft of rights that are set out in our labour jurisprudence. I'm thinking now of my work through the Casual Workers Advice Office. It has alliances with farm worker organizations. And I'm thinking of the many, many working women in our country who are single mothers, who have to take sorry, I think the mic went off. They have to take whatever work is available, even when that is when it requires sexual favors, even when it requires working overtime without pay, and they're unable to, although they know their rights, they're unable to enforce their rights, because in enforcing their rights, they will very likely lose their only source of livelihood. And so one of the things that we need to do, it's not something that judges can directly do, but is to make sure that the law starts to close the gap between the existing rules and people's ability to actually access those rules and make them real. And when you talk about activist judges, yes, I do think it's important. It's part of transformation of the bench. It's important to have a diverse range of voices and experiences and backgrounds on the bench, so that a diverse range of voices and experiences can be heard by the bench. To the extent that the bench can develop the common law and interpret existing laws through the lens of the Constitution, all judges are duty bound to do that.
I am more concerned about farm workers, and particularly those that are subjected to zero-rated contracts. And I just want to get your view whether these kind of contracts should be regulated by the LRA, or we should leave the situation as it is now. As far as I know, there is only one award that was handed down by the CMA. Apart from that, I have not seen anything that deals with zero-rated contracts in South Africa.
Yes, these 0-hour contracts, I think what you're calling zero-rated contracts, it's a contract where you contract to work for somebody, but you're not guaranteed any number of hours, which seems to be completely at odds with any notion of human rights, because you're required to make yourself available for work, I suppose, at your own expense as well, but you're not guaranteed any minimum hours. And yes, I do believe that legislation should address that. I think it was a gap in minimum wage legislation. Minimum wage legislation legislates a wage per hour, but that then is interpreted as only being if you work for that hour. Minimum wages should provide for a basic living wage for anybody who works per week or per month. Otherwise, it becomes meaningless if one's only going to be given 1 hour's work.
Thank you very much, Advocate Happy. Thank you very much, CJ.
Commissioner Mangen?
Thank you, CJ. Good afternoon, Advocate Happy. Good morning.
It's been a long week.
It has been a long week, indeed. I'm encouraged by the fact that you come from the trade union movement. Now, the Labor Relations Act has at its center the notion of fairness to both the employer and the employee. And with regard to dismissal, the jurisprudence that has been coming from the Labour Court and CCMA awards suggested that the country has rejected the reasonable employer test on dismissal. But what we are seeing now, recently with regard to certain judgments, it's like there is a reversal of that jurisprudence, and the judges and commissioners are reverting back to the reasonable employer test in the determination of whether it is fair or not to impose the sanction of dismissal. Instead of looking at fairness, they look at what a reasonable employer would do. And as I read the Labor Relations Act, I do not think that is right. Am I correct in that assessment?
I don't think I've noticed that trend. I think it's been very clear since Sidumo that it's fairness, and to the extent that fairness is a value judgment, it's the commissioner's sense of fairness that determines whether a dismissal is fair or not the employer's sense of fairness or sense of reasonableness. But maybe you've read something that I haven't, and I'd be happy to engage with that if that's the case.
But do you accept that the Labor Relations Act rejects the reasonable employer test in the determination of the fairness of the dismissal.
Absolutely, because that test is a deferential one, and there should never be deference. Fairness, as you've pointed out, is a matter of fairness to both sides. And the context is important. The imbalance of power, for instance, is important contextual information.
Thank you, Advocate Harvey.
JP Tlalesi?
Thank you, Chief Justice, and good morning, Advocate Harvey.
Good morning.
I recognize you, LAC assigned matter. Yes, just to explain something that causes confusion at times. Is there any distinction between the powers of the labor court and the jurisdiction of the labor court? How would one describe that? Thank you.
Those two things do get mixed up from time to time, Commissioner. Section 157 sets out the powers of the court, and Section 158 sets out its jurisdiction. Jurisdiction refers to the matters that the court may apply itself to. There are certain matters that fall outside of the jurisdiction of the labor court, and it won't be seized with those matters. The powers of the labor court refer to the powers that it can exercise once it is seized with jurisdiction. And those include powers of, but those include the kind of remedies that the labor court can grant. That, in my understanding, is the difference between powers and jurisdiction.
Thank you, Chief Justice.
DP Zwane?
Thank you, Chief Justice. Morning, Advocate Harvey.
Morning.
My question to you is just a simple one. Now, you've alluded to the fact that the unions now are sort of less powerful. And in terms of Section 161 of the LRA, the employees may be represented by the office bearer of the union, either at the CCMA level or at the labor court. Now, the fact that the unions now are sort of less stronger than they used to be in the 1990s, I'm talking about the union like SACAU, FAU, SACTU, NUM, NUMSA. Those unions used to have a very good shop steward who represented employees effectively, either at the CMA level or the labor court. Now, with the unions now having become sort of less in terms of, well, weak in terms of their power, how have you found the quality of legal representation provided by the office bearer of the union, like the shop steward? And if the quality of legal representation has been compromised, are you aware of it? And how do you assist the litigant to make sure that they receive proper representation or assistance in terms of presenting their case?
Yes, thank you for that question. That is something that has really concerned me a lot over the last years. The quality of representation by union officials when they have appeared before me in the labor court has been good, but it has only been the biggest and the most well-resourced unions, usually in the public sector, who do send union officials to court. And those union officials are, in fact, it's usually officials and not office bearers, and they usually are excellent. But as you point out, the union movement that existed at the time that the LRA was crafted was a union movement that had in its ranks large numbers of highly skilled and trained and competent shop stewards, officials, and office bearers. And I do believe that the LRA was designed on the assumption that that situation would continue. And indeed, the dispute resolution functions of the CCMA are dependent on having that quality level of rigorous, highly trained, highly competent officials in the trade unions. At CCMA level, Rule 25 provides that workers may only be represented either by a lawyer in certain instances or otherwise by an official of a registered trade union, and that's where the first problem comes in. More than 4/5 of the workers who bring disputes to the CCMA do not have a registered trade union and cannot afford a lawyer, and that means that they cannot be represented according to the way Rule 25 was. In 2016, we brought a constitutional challenge to that rule to the Labour Court. The matter wasn't heard, but in fact there was a settlement agreement, and subsequently the CCMA amended its rules, but only insofar as it now allows for a discretion. Commissioners now have a discretion to permit alternative representation in a given case. And that rule ought to now open the door for community advice officers and other community organizations to assist workers in the CCMA, but we're finding in practice that the discretion is exercised haphazardly, and that most of the time workers do find themselves unrepresented in the CCMA. You asked about the Labour Court. I'm very familiar with dealing with lay persons because I was a CCMA commissioner for a long time. I'm not uncomfortable dealing with lay persons in my court. I have found that it is very seldom that a lay person does reach the Labour Court. And I think that's partly because people just don't know how to access it. And through all of these other levels, including through the CCMA, they just haven't been able to access representation. But when a lay person is in my court, I feel quite comfortable. I, for many years, had to work with the difficulty of assisting a lay person without supporting their side of the case. It's a fine line to walk, but I believe one develops the ability with practice. But this is one reason why I've worked so hard to build alternative employment law capacity in the legal NGOs, the public interest NGOs, because of that diminishing ability to represent workers by the trade union movement. At a certain point, even Legal Aid SA didn't have an employment law department. But now I've seen that Legal Aid SA is starting to appear in the courts, which is a good thing. And I've worked very hard to establish labor law capacity at the, there's a new labor law unit at the Lawyers for Human Rights that I've been involved in mentoring and training those attorneys. LRC has also taken on some labor law matters. And so through a combination of hopefully supporting the rise of a new trade union movement that suits the needs of modern workers, plus developing capacity in the NGOs, hopefully in the next few years we'll see a reversal in that pattern where workers are not properly represented. But when there are laypersons, it does pose difficulties. They do need a lot of explanations and support. And of course, with a very busy and burdened labour court role, that can slow things down a bit. But at the end of the day, the main principle is that everybody must have access to court. And when they get there, they must be treated with courtesy, and the procedures must be made accessible and understandable to them.
Thank you, CJ.
Thank you, TP. There are no further questions for you, Ms. Avi. Thank you very much for not giving up on us, and all the best. You're excused.
Thank you, CJ and commissioners.
Shall we clear the room for deliberations, please? afternoon. Is it afternoon, Ms. Poso? How are you?
Good afternoon, Chief Justice. I'm good, thanks. How are you, ma'am?
I'm fine, thanks.
Thank you.
Can we begin? Can you start the interview?
Yes, I'm ready.
All right, thank you. You hold a BA degree from the University of Lesotho
That's correct.
and an LLB from the University of Witwatersrand.
That's correct.
You also have a diploma in labor relations from the University of Johannesburg.
Yes, that's correct.
Right. You have been an attorney since 2003, not so?
That's right.
At least that's when you started your articles. And then you worked in a couple of law firms. The first was a partnership, including you, which was dissolved.
Yes, I did my articles at Makobe and Dolamo Attorneys, and then I went into partnership with Mr. Dolamo thereafter, yes.
But then that was dissolved subsequently.
Yes, it lasted for about 3 years.
And you had one for your own account,
That's correct.
but you closed it down.
Yes, I closed it down as well to join Krichel Heinzen,
Where you are currently.
where I am currently, yes.
And that is since 2015.
That's correct.
Right. You have acted as a judge since that year, actually, since 2015. And as I look at your application form, you've acted, you acted in 2015, 2016, and you've acted since 2015. Every year. I'm just connecting the dots.
Let me just correct it, because I think I've given the impression that I have been acting continuously. I acted by invitation between 2015 up to
2025.
2025, yes.
Every year.
Except 2022. But cumulatively, I don't know, by my own count, it's probably around
I counted 14 terms.
18, sorry,
I
18
counted-
months.
I counted 14 and some odd court terms. Is that
could
about
be-
right?
Yes, that could be right.
Well, that is a long, long time. And during these many acting stints, I would imagine that you've sat in all the courts.
Well, I initially sat in the civil courts in Gauteng, and then in Mpumalanga I also I sat mostly in the civil courts, though I have sat in the criminal cases as well.
Well, for the most part, you have acted in Middleburg,
That's correct.
but your earlier stints were in Pretoria and Johannesburg.
Yes, and that was before the Mpumalanga division was opened. Yes.
All right. And how did you cope with the frenetic work pace in those two courts? Did you manage?
I did manage, but the workload was really something to behold, especially the unopposed motions. Yes, but with the assistance of some of the senior judges, I was able to cope.
Right. You state that your practice is largely conveyancing and HR work, and that you have not had, I picked up somewhere that you've not had a lot of opportunity in the criminal court. Is my understanding correct?
Well, I did have experience in the criminal court, obviously, when I was still with Makove and Dolamo, I did magistrates court trials, but mostly in the district courts. My biggest problem with court appearances was the issue of Africans, which was still used widely at the time. But I did go to court up until the partnership with Dolamo ended, but not as much as, for instance, the regional courts, the seniors would attend that. So I was confined mostly in the district courts for both civil and criminal matters.
All right. And you would have conducted criminal trials and certain criminal appeals in the High Court.
I did sit in criminal appeals now in the High Court, yes. And at the time when there was a backlog with criminal appeals, I think I sat in about 14 of them with the retired Judge Cynthia Pretorius in Middleburg.
Right. You have listed a few reserved judgments, but I don't quite understand the manner in which this is reflected. What is the status of these matters? Because what is the status of these matters? Let's just take us through each one of them. It's at page 15 of that record in front of you. Paragraph 9.5.
Okay, all these judgments have since been delivered. Yes, and
But they had not been delivered when you completed this application form.
not when I completed the form. No.
I raise this issue with you because some of them are quite old. The oldest dating back to 2018. What KK Mashabela versus RAF? What caused the delay there?
No, that is the case number.
Is the case number?
Yes.
Oh, I'm sorry. I was confused. I thought there was something I was missing. Okay.
Yeah.
So it is all matters that you had in 2025.
Yes, that's correct.
All right.
Yeah.
Well, that's quite an output. So you delivered all of them.
All of them I have delivered.
I do apologize.
No, not a problem.
All right. Have you written any judgments?
Sorry.
Have you written any judgments during your acting stints?
Yes, I have, and I do realize that there was a concern that I don't have any reported judgments, but I have written quite a lot of judgments. In my own count, I think it's more than 83 judgments that I have written.
But none of them reported in the conventional law reports.
There's probably about 3 that I noticed that were reported, yes.
Oh, so you have 3 reported. Don't be bashful about it. You have 3 reported judgments.
Yes, they are there.
Okay. All right. After that almost heart attack I gave you, let me hand over to JP Mpahlele to put questions to you. Oh, and by the way, I do apologize, Judge President Mpahlele and Premier Ndlovu, for not welcoming you earlier. You are welcome.
Thank you, Chief Justice. Ms. Bam, maybe to start about your acting stints, which started in 2015. Why now, after so long? Why are you just applying now for the position of the judge?
JP, I would have probably done this earlier, but I think it was a personal matter of, family dynamics, because if I were to apply, for instance, to Gauteng, I would have had to move. And I've been a school mom for some time to my grandson, who is now completing matric. So it would have been a bit of a problem for me to move from where I am to Gauteng. Insofar as Mpumalanga is concerned, I think it was just a matter of me convincing myself that I was ready. And, I'm here because now I feel I'm ready to take the next step. And yes.
Okay. Thank you. And maybe if you can give us in respect of the reserve judgment, to say all of them have been delivered. Maybe on average, how long do you take to deliver a judgment after a hearing?
It normally ranges from about 3 weeks to, let me say, I've never gone beyond 3 months with a judgment, but 3 weeks and probably to the almost last week of the third month, but I've never gone beyond 3 months for any judgment.
Okay. And partly heard matters, have you ever had?
I only had one, but that was a leave to appeal, and it needed a record which took a bit of a time to obtain, but that has been dealt with already. It's finalized.
Okay. Thank you. And you, maybe before I go to the issue of Middelburg, have you ever been subjected to any disciplinary hearing by any statutory body?
No.
No. I just want you to share with us your experience of acting in Middelburg. You place on record that you only acted in Middelburg in Mpumalanga. Your experience, especially on infrastructure related, compared to Gauteng, where you used to act.
Well, the court house itself is a very old building, and there isn't much separation between judges and staff and the clients. Most of the time, when you walk in the passages, you are bound to bump into a client, and it's not an ideal situation, but obviously it's a new court, and I don't know what the plans are, but I think it will improve with time. But I mean, as judges, you go there to serve, and there are some small inconveniences, but we overlook them and get on with the work.
Okay. Thank you. We noted on the comments by the legal practitioners that there's a note that you have matured since your initial appointment, but there's a concern that you are soft-spoken and at times it's perceived as not being assertive. What do you say about it? What's your comment on it?
Okay. Obviously, as somebody who does not do court work as it is for practice. It was a bit of a confidence issue when I first started. But my personality is what it is. I'm not a loud person, and being assertive or not being assertive to me is not the issue. The issue is at the end of the day, you are able to control your court and you get the work done at the end of the day.
Thank you, Chief Justice.
Thank you, JP. Premier, do you have any questions for the candidate?
Chief Justice, thanks for this opportunity given to me also to participate on this interview. Greetings to my JP and all members of JSC. Ms. Bam, I'll ask you just only two questions. One question to deal with the doctrine of the separation of powers, your understanding on the separation of powers, can you share with us?
Okay, there are three branches of I don't know how to put it. There is three branches of the state in our constitutional democracy. We've got the judiciary, the legislature, and the executive. Separation of powers, insofar as the courts are concerned, concerns the issue of interference into the sphere of other arms of government. So separation of powers means each and every sphere of government must respect and not interfere in the other arms of government spheres. And it also goes to the issue of what is normally called a judicial overreach in some quarters where the court, for instance, would make an order that goes to the core of the powers that is a state organ is empowered to exercise. And so it's about accountability, it's about transparency, and it's about I'm sorry, I'm just
Okay. Oh, you are done. Oh.
yeah, I'm sorry, I can't. I'm trying to find the words, but basically, separation of powers is about the issue of the boundaries that protect each arm of the government.
I can see that you are not relaxing. These are your colleagues. I want to request you that please you must relax. I know that you know these answers because these are your day-to-day work that you are doing. But if you're done, then I can continue. But I want to humbly request you that please you must remain calm, relax.
Okay, I will try to relax.
Okay, no. Thanks, Ms. Bam. The second question relate to the performance of judiciary. can you please sum up the performance of judiciary in the last few years in enhancing democracy and ensuring its own accountability and that of the other two arms of the state?
Can you repeat your question, please?
I am saying that I want you to sum up the performance of judiciary in the last few years.
Okay. In my observation, I think
I'm sorry. Well, it appears that the candidate is able to answer the question because she started saying something. But I was going to say perhaps the question is too broad. I'm struggling to understand precisely what it is you're looking for. If you could just try to make it more specific.
It's not specific, just general. I wanted just to give you an opportunity to explain. So I don't want just here to be specific.
All right, just for my own edification, just put it again. Just repeat the question.
The general performance of judiciary
All right.
in the last few years.
Okay.
Yeah.
So, in transforming the state, well, the commissioners here are adding things I had not heard before. I'm sorry, Premier. I don't mean to mangle your question. Just repeat it as you had put initially to the candidate.
Oh, you want me to repeat the question?
Yes, just repeat it.
In general, I want to explain about the performance of judiciary in the last few years. That is the question. That please, would you sum up the performance of judiciary in the last few years in enhancing democracy and ensuring its own accountability and that of the other arm of the state? That is the question.
Right. I got it.
Okay. I'm not sure if I'm in a position to speak on behalf of the judiciary in general or in this one, but so far there is a case law that has emerged from the courts, like the constitutional courts, where issues such as evictions, issues such as declaring certain acts of executive unconstitutional. So I think the courts or the judiciary has actually done a good job to ensure that the constitution is adhered to in whatever that the government or even in some instances what parliament does. So they have also ensured that the rights that are entrenched in the constitution, whether they are individual rights or they are rights that are given to state organs, that they are protected, and when it comes to implementation, that they are done fairly and in accordance with the principles of legality. So the courts have been the enforcement arm of the Constitution in that respect.
No, thanks, Mambam and Chief Justice.
Thank you, Premier. Minister?
Thank you very much, CJ. Good afternoon, Ms. Pam.
Good afternoon, Minister.
No, thank you very much. I think you are going to have to assist us because your questionnaire doesn't have much information for us to be able to make much out of your work. And I'll go to the section question 10, where you were asked about the significant contribution you've made. What would you regard as your most significant contribution to law and the pursuit of justice in the country, in South Africa? And I noted that in terms of law bodies, you don't seem to belong to any of the law bodies, and then you don't have any publication, either articles or participation beyond. I think the participation I've seen, which is a good one as well, is on NGO work. So would want you to tell us more about your work so that we can be able to determine. So if you could elaborate in what you have reflected here. I see you've reflected the work that you've done specifically about your judgments, for example, one of them where you refused evictions from a municipality. How would we interpret that as a contribution to justice in South Africa, because it doesn't have much detail there in how that has contributed in pursuit of justice, but also significance in terms of law, if you can elaborate. I just pulled one of the issues that you've listed there that relates to the judgment. What is the significance about that work?
Okay, first of all, I agree with you on your observation about what I have on paragraph 10, because these are issues that the law actually enjoins the courts to do. So I wouldn't necessarily also put them as uh, contributions in the sense that the question wanted me to elaborate. Um, the the Constitution says that, or it protects the right to property, and it also says that nobody should be evicted from their property without a due process. So obviously over the years, the courts have interpreted, and especially the eviction legislation, it has been interpreted in such a way that we are sensitized to always look at the impact that an eviction would have on the people who are or who will be rendered homeless. So when you are dealing with a case like that, that is what you should actually have in mind throughout. But in further elaboration to the issue of my contribution, you did mention that I don't belong to any of the bodies. But I have been, I have been called on to give addresses to young attorneys, both at Saula and at Nadel. And in those addresses, I always make sure that I indicate to the participants or to the audiences the importance of practicing law ethically, and also the importance of helping people who cannot afford the legal fees that we charge. Within child welfare itself, I contribute by making sure that I draft policies and train management. And recently, when we had a fundraiser, I invited the office of the child of the family advocate to address the audience. So they are aware of its existence and what help they can get if they are having issues about parental responsibilities. I think something else that I could mention, around 2019, I was invited to give a talk to employees of a mine called Kwezela that belongs to Anglo during Women's Month. And it was a topic about gender-based violence and the solutions that the law has got for victims. So maybe I have not published papers or addressed conferences in that conventional sense, but wherever I get the opportunity, I do promote the issue of legal rights.
Just one last one, CJ, from my side. Following up on what you have raised in terms of, I think, one, when we look at Mpumalanga, a rural province where majority of young women will grow up without having much of role models to look at. But those who come from legal sector area would not even have the opportunities of having mentors. Have you considered, because I don't see anything that talks to that regard, how you support young women besides attending and addressing conference or giving a talk? Just the issue of mentoring of young women, especially having acted as a judge from 2015 with your exposure, taking up young women as part of transformation in our society, but giving them opportunities. Have you considered that? And if you've done, what has been the work that you have done in that area?
As we speak, Minister, I am mentoring two young ladies who have just opened their practices. One is a conveyancer, and she actually she did her articles in my firm, but she moved out to open her own practice. So I have assisted her with the conveyancing issues. And I have also, as a notary, because she's also a notary, I have introduced her to the execution of mineral rights to the extent that now when I'm acting and a client needs help, I refer them to her to assist. And the other one also just opened a practice last year. And she actually approached me for mentorship, and we are basically restructuring that relationship as we speak. But I have also, because our firm doesn't do a lot of what we call general litigation, when there is a matter, like recently I referred a divorce matter to her, and she dealt with it, and the feedback that I got from the client was a very positive one.
Thank you very much. This is information that could have helped us more in the questionnaire.
I agree.
Thank you very much.
Thank you.
Thanks.
Thank you, Minister. Commissioner Marumakai?
Thank you very much, CJ. Good morning, Ms. Baum.
Good morning.
I had an occasion to read at least some of your judgments, and I just want to ask you a question with regards to at least two of them. Let's start first from page 24 of your document. It is the matter of Inzalo Utility Management Services versus Victor Kanye local municipality.
Yes.
This is a matter we dealt with the Arbitration Act. There was an arbitration between this party and the municipality, and you had to deal. Apparently, one of the parties did not attend an arbitration, and you had to deal with that. I wanted to ask you a content-based question, but nonetheless, there's something that I want to take with regards to this case. When I read this case, I saw that in paragraph 8, you refer to the Arbitration Act, the way you have structured the judgment. Paragraph 9, you are dealing with the arguments, and you narrate the arguments. Then paragraph 12, you are dealing with the analysis. Then paragraph 15, after the analysis, paragraph 15, you are dealing with what you refer to as the law, and you start quoting about 3 or 4 cases. Then immediately thereafter, you conclude. I don't have a sense of what your view is with regards to the law that you are quoting. It is quite difficult for me to understand your understanding of the law that you, or of the cases that you are referring to, whether you are relying on them or you are placing them as a matter of information. And I don't get a sense as to how they are assisting you to arrive at the conclusion, because immediately after citing them, you conclude. I'm not really sure how you kind of like structure your cases. Do you have any comment on that?
Okay, and unless maybe you are querying the order in which I have put my headings. My analysis is basically based on the arguments that have been advanced by the parties in this matter. And I quote the law in a bid to actually show that what I have here as the analysis and what the law says would lead me to the conclusion that I have in terms of what I have already put beforehand. So I'm not sure whether you are querying the order or my way of thinking.
Um, uh, and I'm not saying you are wrong. I'm just curious as to how you write, because one would think that analysis will come after the law, where you tell us how you marry the law to the facts and the arguments that have been made. And of course, when you look at also at at the second case that I want to refer to you to, in page 58, Sneyman versus Sneyman. The same actually appears. At the end, you refer to cases, and immediately after that, you conclude. In this case, it was a matrimonial case that dealt with Rule 43. I mean, we can deal with the content, but I'm not really interested in the content at this stage. I'm just trying to understand your process of structuring cases, because it appears to me that it's very difficult to understand how you are using the law to arrive at the conclusion that you arrive at.
Well, I'm sorry, Commissioner, I can't.
No problem. Thank you very much, CJ.
Thank you, Commissioner Marumakai. Commissioner Shabangumdao.
Thank you, CJ. Good morning, Ms. Bam.
Good morning, ma'am.
CJ, one of my questions has been covered by the minister. Then I'll be left with one question. Ms. Bam, do you think judges can assist in the transformation of the judiciary? And if yes, how? If no, why?
I'm sorry, Commissioner, I can't hear you.
I was saying, do you think judges can play a role in the transformation of the judiciary? If yes, how can they do that? If no, why?
Okay, I believe that they can, and obviously, okay, I don't want to misunderstand your question. You're asking if judges can advance transformation.
Yes.
Oh, okay. Yes, I believe they can, because they are in a position of, number one, they're in a position of leadership. Number two, with the kinds of decisions or judgments that they make, they are able to change the complexion of how things are done in society, how decisions are taken, or how certain issues are dealt with. Um, for instance, we've got the recent decisions now where the issue of gender has come under the spotlight, um, regarding, number one, the leave, maternity leave for fathers. Number two, we have the issue where the courts have said it's permissible for a male to take on a spouse's surname, and recently also where the the life partner in a situation where a child is conceived by way of IVF, that he or she is a parent for all intents of purposes. So that is a transformation, in my view, that brings society closer to the realities of the life that we are living now.
Thank you, Ms. Bam. Thanks, CJ.
Thank you, CJ. Good morning, Ms. Bam.
Good morning.
Could you please just explain the extent to which you have dealt with criminal matters as a practitioner, but also I see that you've acted since 2015 as a judge. Can you also explain how many criminal matters you've done, how many criminal trials, and perhaps any other experience in that field?
Okay, as I have indicated in my papers, I haven't had that much criminal practice experience. First of all, because when I started, um, the language used in the courts was still Afrikaans, which I couldn't speak. So most of the serious criminal matters were done by my seniors. So I would be sent to do a small matters of your thefts, your bail, and so on in the district magistrates court. Um, when I started acting in Mpumalanga, I did 3 weeks in Brighton. Uh, that was for criminal matters. Um, I presided on two cases, criminal cases, and I think the rest, about 3 of them, were plea bargains. So I didn't actually get to participate much in that. But other than that, the most participation that I have had is through sitting as part of a full bench or a full full bench in appeals, criminal appeals. I think all in all, besides the 14 that I did with Judge Pretorius, I think the total was about 23 that I did.
So if I understand you correctly, you've only done 2 or 3 criminal trials in the entire Actingston period since 2015. Is that correct?
That's correct.
And have you used assessors when you acted as a judge?
Sorry again?
Did you use assessors when you acted as a judge in these criminal trials?
No.
You did not?
No.
May I ask why not?
Well, I don't know if it's something that I was supposed to do, but I didn't see the necessity.
Okay. So you felt comfortable enough?
Yes, I was comfortable.
All right. Thank you. Thank you, CJ.
Commissioner Muimang?
Thank you, CJ. Good morning, Ms. Bam.
Good morning.
Just one from myself in relation to the JKRS versus DS case that you highlighted as part of your contribution to jurisprudence. In terms of the divorce proceeding, in case of divorce proceedings, where there are competing interests between parents and a child, whose interest will reign above the other? And in responding to that, apply the maxim: the court is the upper guardian of a minor child. Thank you.
Okay. I didn't get the full question. If you don't mind, Commissioner.
What is your understanding of the maxim, the court is the upper guardian of a minor child, as you applied it in the divorce case that involved JKRS versus DS? The judgment that you highlighted as part of your contribution to jurisprudence in your questionnaire. Thank you.
Okay, obviously, in terms of the Constitution, the children's best or the child's best interests must always be taken into account in every matter where a child is involved. So my understanding would be that where the parties obviously in divorce matters, in most instances, the parties will always fight over custody and parental responsibilities and so on and so forth. But at the end of the day, we have to look, that's the deciders of the case. We have to look at what decision will best fit the best interest of the child. And it does not necessarily mean, as it used to be the case, that, for instance, in a custody matter, that the mother is best suited to raise the child. You actually look objectively at what would be in the best interest of the child.
Thank you, Ms. Bam. Thank you, CJ.
Thank you, Commissioner Muimang. JP Tlaleti?
Thank you, Chief Justice. Good day, Ms. Bam.
Good day, sir.
Yeah. Just one observation that I make. You appear to be someone who's very humble and modest. And looking at your questionnaire, there's an element also of honesty, especially you don't claim things that you think they will enhance your chances of being appointed. if one looks at paragraph 6, you don't claim to have done any criminal law, administrative law, constitutional law, labor law. In that, and then your CV, as I look at it, you've just given us enough that you think we need to know. But coming to the kind of work that you've done, the allocation normally is done by the judge president or the senior judge in the division.
That's correct.
And they allocate the work according to your strength. Is that the reason why you were mostly given civil cases to deal with?
Well, in as far as Mpumalanga, or not Mpumalanga, Middleburg is concerned,
Yes.
the number of civil cases has grown to such an extent that probably it's the reason why the JP is often relying on acting judges, because there is only 3 permanent judges, and one of which will be obviously in the criminal court. But the 2 permanent judges that are there cannot tackle the amount of civil cases that arrive. So I would like to think it's more about the proper deployment of resources than saying, I prefer this one here or the other one there. But I am more helpful in the civil court than I would otherwise be in a criminal court.
And I note that the practitioners in that area are quite happy and they support your appointment.
I don't have any doubt that they do.
Thank you, Ms. Bam. Thank you, Chief Justice.
Thanks, JP. DP Zund.
Hey, thank you very much, CJ. Morning, Ms. Baum.
Good morning, Mr.
Okay. Commissioner, let's just ask you about your extent of the extent of your experience in criminal matters. And you indicated that you have done about 3 cases. Is that so? Is my understanding correct?
Yes,
on
that's
your
correct.
own.
Presided over, yes.
Okay. Just sometimes criminal matters or trial can be a little bit tricky. Now, let's say there's enough at the end of the state's case. The state closes its case, and the defense apply for Section 174. Do you understand the test that is applicable at that stage? And if so, what is the test? And if the defense, if the Section 174 is refused and the defense decides to close its case, what is the applicable test to determine the guilt or otherwise of the accused?
Okay. First of all, after the state has closed its case and the defense asks for a 174, the presiding officer or I would have to first determine if there is a prima facie case that has been made, a case that the defendant has to answer, or the accused, let me put it like that, has to answer. But if the accused decides not to put its case before court, then obviously I will ask for the closing arguments, and obviously then the mitigating and aggravating circumstances, and to the point that I'll be able to do my judgment.
Sorry, Chief Justice, if I could. I'm not sure if the DP is finished.
Yeah. Okay. Well,
Or maybe
that's
you
an
want
answer
to
that
make
she has
your own
given.
follow-up to your question.
Maybe you can do a follow-up. That's an answer that she has given. Okay.
Ms. Bam, I'm not sure if you understand the crux of the question, because we are now talking about mitigating circumstances, even before you've made a decision. And the question was, what is the test? The case is closed, and the accused has decided he's not going to give evidence. What happens next? And the reason I ask is because you can't now go to mitigating circumstances after the case has just been closed, because mitigating circumstances is about sentence.
Well, obviously, I will have to evaluate the evidence that has been given before me so far, and then I can decide to convict. After which, or if I convict, then after which, then the other steps would follow.
Yes, but the question was applying what test? All right, thank you, Ms. Bam. Thank you, Chief Justice.
Yeah, perhaps Deputy in his wisdom as a judge of long standing knew well when to quit. I think it's a thing of counsel and academics to want to wrestle with a candidate who gives an answer they think is unsatisfactory until they get what they want. Well, any further questions, colleagues? No? Thank you very much, Ms. Pam. You're excused.
Thank you, Chief Justice. Thank you, everybody.
Is it Holong? Oh, I got that right. Are you ready? All right. How are you? All right. Never says good. Oh, okay. Okay. Thanks, JP. I did not notice. Um, you hold a number of academic qualifications, BA Law, LLB, both obtained from VES, then a BA Honors from the University of the Free State,
Yes, Chief Justice.
and a Master in Business Leadership from UNISA,
Yes, Chief Justice.
and 2 certificates from institutions overseas, a certificate in international commercial arbitration from Colombia.
From Columbia Law School, Chief Justice, that
Uh-huh.
enabled me to be admitted as a fellow of Chartered Institute of Arbitrators in London.
Mm-hmm. Is that the one relating to your membership as a... No, we'll get
Yes,
to that.
as a fellow of the Chartered Institute of
Oh,
Arbitrators.
yes. I wondered about that. All right. And a certificate in adjudication.
Yes, I have a certificate in adjudication from Asian International Arbitration Center in Malaysia.
Mm-hmm. You have practiced as an advocate for 25 years, you say?
Yes, I've been a legal practitioner effectively for about 29 years, and 25 years of which I've been an admitted advocate of the High Court.
Having joined the Johannesburg and Pretoria bars in 2011.
Yes, Chief Justice.
But before you came to the bar, you had held various positions in the public service.
Yes, I've had various roles from a legal advisor in the Office of the Premier in the Free State to legal advisor in the Department of Environmental Affairs and Tourism to being a senior manager and director in the Department of Provincial and Local Government, now known as COCTA nationally. I also headed governance at the South African Local Government Association. I've also been a chief legal advisor as executive director at Ekurhuleni Metro.
And you state that in those roles you helped draft various policies and legislative bills and led the review of policy frameworks, and you cite a number of key legislation, including the Systems Act, Structures Act, Demarcation Act, POCA, NEMA, and others.
Yes, I was lucky enough to be at the cutting edge of local government transformation and the establishment of our system of government, which positioned me in the various roles I've played in the public sector to draft a number of policies, to facilitate a number of bills that we saw through legislatures and through parliament. Even during my activities in private practice, I've continued to maintain active interest and participation in support to the public sector. I remain as a governance audit committee member in the Free State Province, overseeing portfolios such as social development, arts and culture, in the Northern Cape, overseeing the Office of the Premier, Department of Health and Social Development. I've also played a role in Limpopo, in various roles. In Mpumalanga, I've in the main played a role through the
Municipal Demarcation Board, and then as senior manager and director in local government, ensuring that there's community-based planning and strengthening of what committees, so that there's participatory democracy.
And you've had involvement in the CCMA. You've chaired various inquiries there, well, at least two.
Yes, Chief Justice, I have also chaired the Audit and Risk Committee, which is a governance committee of the CCMA, as you know, the view being to ensure governance and operational effectiveness of the CCMA, and we made some strides there in making sure that there's improvement in terms of operational effectiveness, case management, amongst others at the CCMA. I've also played a role at NEDLAC, where I chaired their audit and risk committee as well.
All right. You list an acting appointment in the North Gauteng High Court as early as 2004.
Yes, Chief Justice. I have about 40 weeks, I think, under my belt. I've acted in Gauteng. I've acted in the Western Cape. I've also acted at Thembalethu Circuit, local division of the High Court.
Where is Thembalethu? Is that in the Western Cape?
In George, yes.
All right. So how many terms is that in all?
4 terms.
Including your very first acting stint?
Yes, Chief Justice.
Okay. And did you do the whole gamut of cases during these acting stints?
Yes, it was quite exciting. I dealt with trials, opposed motions, unopposed motions, divorces, criminal reviews, criminal appeals. I sat on full court, full bench. I dealt with, various interlocutory applications. There's not much I've not been able to touch in the various acting stints.
And you've written judgments?
I've written numerous judgments, Chief Justice. I'd hoped to follow up on your good footsteps when I was in the Western Cape, but I failed.
Not many have achieved that feat, I'm afraid. Only 2 by today's count since. So no one has yet broken that record. Any of these judgments, these many judgments reported?
Yes, Chief Justice. The one I think which is of some significance is the Marman and 16 others. There was a consolidation of 16 different plaintiffs against the Road Accident Fund. There's also Prudential Authority, I beg your pardon. Prudential Authority versus Habib Overseas Bank.
Your last acting stint was in the first term of this year?
Yes, Chief Justice. But I continue. I continued during recess for a further 2 weeks. I was allowed to do that.
This past recess?
No. The recess passed
following
the first. Yes.
Oh, all right.
And I've been able to deal with a number of part-yet matters. I'm only left now with one part-yet matter, and I've been able to dispose and write all my judgments. So I don't have any reserved judgments.
You've delivered Naidu versus Naidu?
Yes, I've delivered my reserve judgments and within the 3 months stipulated period.
All right. No, thank you, Mr. Hulong. Over to you, JP Mpahlele, if you have any questions for your candidate.
Okay, thank you, CJ. And how are you, Mr. Kono?
I'm fine, JP.
Thank you. I just want to clarify one aspect. You're saying your first term at the first 18 stint was in 2004, and I note on page 9 at 2004 you were still a director, senior manager of local government. Were you?
2024. I beg your pardon.
Or maybe you didn't hear because the CJ mentioned it. That is 2004. If you go to the page, it's written is two. So I thought it was a typo. So when you confirmed it earlier, I thought maybe you were called. So you are saying
2024.
it's a typo here.
Yes.
On the page, you didn't act in 2004. You started
2024.
last year.
Yes.
Okay. Thank you, sir. And the reserve judgment, you say you don't have at the moment.
I've cleared all my reserved.
What's your turnaround system? How long do you take? On
Well,
average.
well, I had one party matter last week. I was able to deliver my judgment on Monday. I had one party matter on the 23rd. I think within, it depends on the complexity of the matter I have to deal with. Sometimes it takes me a month and the workload that I have to deal with. So it all depends, but I try as much as possible to clear all matters that come before me.
Would it be fair for me to say it's an average of a month?
Yes,
Okay,
JP.
thank you. And I heard that you have a partly hate matter.
Yes, I have a
How
partly
how long has it been going on, this partly hate matter? When did you start with it?
I started with it in January, but the parties, the two councils on both sides, the matter was in fact set down for about 3 days. It's about 8 parties against the Minister of Police. No, yes, there are about 8 defendants in the matter, but I think they had underestimated the amount of time to properly hear and conclude the matter. So when the matter was allocated to me, it had been allocated for about 3 days, but in the fullness of time, it couldn't be concluded in the earliest time that they were able to find a date that could be agreed with, in spite of our pressure, was now, I think, in November, the first week of November, we have set aside a full week to be able to dispose of that. Both councils had to go to hospitals for various reasons, and for the whole year, they indicated they were unavailable, despite our prodding.
So you started January last year?
No, January this year.
Okay.
So it should be able to conclude, I think, first week of November.
This year?
This year, yes.
No, I hear you speaking about the whole year. That's why I got confused. Okay, then it's fine. If I just need clarity on paragraph 8 on your 18 things. You just mentioned like the first term of 24. Now we know you corrected it is 2024. Are you saying in all these, is it a full term or were you called for part of a term? Maybe if we can start with the first one in Gauteng. Your first instinct was the first term of 2024. How long? Was it the whole term or some weeks?
No, it was some weeks.
How many weeks?
I think it was about 2 weeks.
2 weeks.
Yes.
And the third term of 2024?
I think it was about a term thereabout. So was the.
The third term, how many weeks?
The third term, I think it was from the 21st of July. So it was about half a term.
Half a term, it will be about 4 or 5, depending on the number. So I'll just note it out, 4 or 5. And then the fourth term of 2024?
It was a full term,
Full term.
until about the 6th of December.
Okay. And the one at the Circuit Court, Tembale 2?
I had 3 stints of 2 weeks each.
3 times 2 weeks?
Yes.
Okay, thank you, sir. Do you have any experience in our court, in maybe your experience in Mpumalanga as a whole?
Yes, I mean, I'd been intricately involved for a number of years, both at Department of Provincial and Local Government.
Yeah, maybe if you can limit, just limit to the court, to both courts, the main seat and the local seat, the one in Bombela and Middelburg.
No, I've not acted in the division, but I have, extensive experience of working in the province.
Have
but
you ever
not in the
appeared?
court.
Have you ever appeared in Bombela or Middelburg as counsel?
No, I've not appeared.
No appearance. So it would be unfair for me to ask you about our working conditions.
No, but I've taken the time to familiarize myself, firstly, with your vision for the division. I know that the division has about 5,000 odd backlogs of cases. I know that you are passionate about taking justice to the people and, in that sense, making sure that circuits in Mpumalanga are strengthened. I know that you are passionate about turnaround, making sure that there are no delays, given the backlog that the division is, the capacity challenges in the division. And I'm also familiar with how your vision as the JP in the province aligns with the vision of the province itself, led by the Premier, which is to ensure that there's economic development, that there's access to justice, that the issue of crime, especially gender-based violence, is dealt with. And therefore, the role which that division has to play, firstly in terms of making sure that there's access to justice to the poor of the poor in Mpumalanga, but also ensuring that there's expeditious disposal of cases, as and when they arise.
Thank you, CJ.
Thank you, JP. The Premier?
Thanks, Chief Justice, Advocate SST Kulo. How are you?
I'm good, Premier, thank you.
I was listening how you were articulating the way you understand Mpumalanga. And I have also decided to limit myself to Mpumalanga, the Premier of Mpumalanga. I want to know your understanding, but on your interaction with JP, I think you were articulating access to justice for all. So I want you to explain further your understanding. What are the challenges? What have you done to deal with it? Or what do you think that needs to be done to address this challenge?
Thank you, Premier, for the question. I think the first thing that needs to be done about the question of access to justice in Mpumalanga that question must be answered by making sure that courts get closer uh, to the people given the sparseness of the province from Kangala, Ehlanzeni, and Gersibande. It should not always be that if people want justice, as in the olden days of the Transvaal, where they had to go to Pretoria, now they must go to the capital. There is some improvement that has been done with the local division, but that is still not enough. If you look at some of the distances that people that otherwise would want justice have to travel. So the strengthening of the circuit courts is something that needs to be done. There is some good work that is, that the JSC has responded to and the JP, making sure that there is now, more capacity in terms of judges, so that, the workload in terms of people having to wait for having their matters heard and disposed is limited. Because the longer people have to wait, the more, let me put it this way, the way I see the question of access to justice. In my mind, my philosophical view on that is that it is no different from the, constitutional rights or the Bill of Rights, access to water and electricity, because the parties that are in conflict, whether between private parties themselves or a poor person against the state, if such a matter is delayed, it affects the ability of that individual or those individuals, if they are private parties, to go on in their lives. So for me, access to justice is expeditious and effective, efficient disposal of conflict between parties, be it between the state or the state and private parties. And regardless of whether they are poor or they are big corporates, mining houses or whatever.
No, thanks. Assume that you are appointed on this position that you applied for. What will be your priority areas?
Well, I will be ready from day one. I know that the JP is passionate about making sure that cases are expeditiously dealt with. I'll make sure that I issue my judgments as quickly as they must be, that there are no delays in terms of being able to pay attention to matters. I'll make sure, I've given myself to understand the JP's leadership and the support she needs from judges. I understand that, the weekly engagements and meetings in the division to be able to drive performance and delivery. So I'll be part of that team, led by the vision of the Judge President, to make sure that where I'm needed, I'm able to expeditiously deal with the matters that requires attention.
Thanks, CJ.
Thank you, Premier. JP Tlaletsi, followed by Minister.
Thank you, Chief Justice. Is it Ntate Kholong or Kholong? It's Kholong.
Kholong, Commissioner.
Kholong. Thank you. Let's start with the nomination. You were nominated by Ms. Dlamini.
Yes, Commissioner.
Yeah. And where is she based? In Johannesburg?
Yes.
And then the second nomination is by is it William Z. Ngoku?
Yes.
Based in Bloemfontein.
In Bloemfontein. But also in Limpopo. He's done some work in Limpopo as well.
In Limpopo, okay.
Yes.
Yeah. I noticed that these two nomination letters are identical. Have you noticed that?
Yes.
Yes. Who drafted them?
I was involved, I was aware of the nomination.
I don't understand. Who drafted the letters?
I was aware of the nomination, Commissioner.
Yes. But that does not deal with my question. Who drafted the nomination letters?
They drafted the nomination letters and provided the relevant information they required in order for the letters to be produced.
And both from different places issued identical letters, same font, highlighted, everything same way.
Yes.
Number of words seems to be the same.
Yes.
So it's not you who drafted these letters.
I provided the information to deal with the quality of the information that will be coming to the JSE.
So you controlled these letters.
I provided
the quality of the letters.
I provided the information for the quality of the information that comes to the JSE.
Okay. And then the second aspect, the organizations. I must say you are doing a very good job by being in the governance and audit risk committees of these institutions. I think all in all there are about 22. Any stipend that you receive from them?
Well, when you sit in these governance committees, it's really, you're coming in as a member of the community, bringing skills as a legal practitioner. Depending on which one you would be, I mean, for example, with the Northern Cape, sometimes they'll say, "No, we don't have a budget. We may not be able to remunerate you, for your expenses." But because you understand it as your role as a member of the community and as a citizen of the country, it's not about a stipend, it's about the contribution you make to make sure that the lives of the people of the country is improved in whatever little corner the institution may be making a contribution. So there'll be different out of pocket expenses. I mean, reimbursement depending on the size of the institution that you engage with.
And what would be your short answer? Are they paying you or not paying you?
Well, the bottom line.
I didn't get the answer.
No, I do get, I think the correct terminology you use
stipend
is a stipend, yes.
Yes. So you do get stipend?
Yes.
The other aspect, how would the judge president of Mpumalanga be in a position to attest to this body about your collegiality, temperament, if you have not acted in that division? It's not a requirement that you must act, let me make it clear. But for this body to understand you, the assessment by the judge president or the colleagues there in Mpumalanga will be lacking.
I mean, I've acted in, at least 3 different courts, and I have, gotten positive feedback during my acting stints from the senior permanent judges, which is why I was also reinvited a number of times. I'm aware that at least in the local division, to which the judge president is responsible for, the lady judges are quite collegial, and I believe that should I get the nod of the JSC, I should be able to make a proper fit.
Yes. You see, my issue is if you are appointed, that will be a life appointment. And we have to make sure that if there could be risk, is minimized at this stage. I don't know if you follow what I'm saying.
No, I do follow what you are saying, but you know, Mpumalanga is a fairly small. I mean, the local division. There's about two permanent judges, so there can't be any at this point complexity in terms of a feat. In any event, the evidence before the JSC is that with the various organizations that I've been able to work with and that I continue to work with for the past 29 years, I've been able to work very well. And by any standard, 29 years it's a lifetime. No different from disappointment should I get the nod of the JSC.
If you were to be given an opportunity to act there, would you accept and take advantage of that?
Well, before the time of Judge President Mpahlele, I have, made attempts and reached out and made, requests to act. But given, because you only get an opportunity to act if a permanent judge goes on long leave, and then you'll get an indication that, you'll be accommodated, but you never get the call. But you understand that given the size of the division, you have to stand in the queue. But that is no bar for the JSC in the event it deemed me sufficiently competent to can get the nod to be appointed, because there's one office of the Chief Justice, and the office of the Chief Justice has expended time and resources in building my capacity as an aspirant judge to be able to take that role in the event that such a nod came.
Yes. No, this is not any negative reflection on your character or qualifications or whatever. I hope you understand it that way. Thank you, Mr. Kholo. Thank you, Chief Justice.
CJ, if I may make a follow-up on... Sorry? I
I'm
just have
sorry,
a follow-up.
I'm juggling many balls as I'm sitting here. That's another emergency I have to deal with. Yes, JB. It's a follow-up to...
Yes, follow-up to...
Please go ahead.
Yeah. It's not very clear to me. You say before, I presume you mean, did you approach the previous JP because it didn't come out clear?
Yes, I did.
You approached him. So you applied to be an acting judge?
Yes.
Is it an ideal situation to apply to be an acting judge?
Well, I require, if you make a request, because I must admit, always had keen interest in being able to improve my capacity and get the experience.
Thank you, Chief Justice.
Thank you very much, CJ. Good afternoon, Advocate. I must pronounce it Holong.
Good afternoon, Minister.
I'm going to start doing a follow-up on what JP raised with you around board fees. Because you said it's a stipend. You've got, as he said, 22 boards. I've looked at them. Audit and risk committees are quite significant in terms of boards. They are appointed, they are boards directly in an organization. And I'm just looking, for example, I wouldn't say CCMA governance, NETLEC governance, audit and risk committee. You also, all of them are chair. I think quite significant of them are chair in terms of where you sit as governance. That's significant income because you'd have preparatory fees and you'd also have a board fee. which, if I'm not mistaken, for a board fee per sitting at audit should be around between 3,000 to 4,000. Am I correct?
Yes, but for a life of an advocate in private practice, that's an act of suicide. It is community. You know, if you've got overheads that you have to deal with, and you get a stipend of 3,000 with respect, it is a stipend, Minister.
It's an income in salary terms in South African context. It could be a stipend to you, but I'm just bringing to your attention that these are 22 committees, 3,000, between 3,000, because if you are chair, it's more than 4,000. I wouldn't regard that as stipend, but let's move on to the next one. On 2, where you are asked in your questionnaire, if you have any publication in the field of law, please list them and identify those. Those in terms of their significance, and state shortly why they are significant. I took note of what you have listed there. These are bills. And I would want to understand your role in the bills, because I don't think you were a lead drafter. For example, single public service bill, it's in public service and administration nationally. Constitutional 12th Amendment will be the Department of Justice and Constitutional Development. The boundaries of municipal bill will be in the National Department of COGTA. The one that I think you would be, from where I'm reading, you'd be the lead, would be the one that refers to draft Free State Tourism Marketing Bill, which would have been. And then I'm comparing that, I want you to answer me, comparing that to number 5, where you list this as being part of your team. So I just want to understand your role and how you, and why would they be significant to you as a contributor, because I looked at that number 2, I followed to say this were contributed, and I'll come to the next one. Because I'm looking at that 2, I'm looking at what you answered in 3, I'm looking at what you answered in 4, and I'm looking at what you answered in 5. For me, it's that if you are not a lead drafter, how do they become significant to you or associated to you in terms of achievement? Perhaps maybe if you can assist us there.
No, thank you very much for that question, Minister. The various amendments of the Systems Act, the Structures Act, the Demarcation Act, and these are just the 3 I can think of now. They were directly under my purview as a senior manager in the National Department of Provincial and Local Government, as it then was, amongst others led by the Minister, Sydney Mufumadi. I also drafted the draft Public Service Act when we had challenges within government around that, and taking it into Parliament at the point, at that point, because we published it. We even took it to the Local Government Portfolio Committee in Parliament. We modified it for local government so that there is seamless, at the time, at least that was our thinking, so that there's seamless transfer of human capital between different municipalities, because we realized that there were different capacities in municipalities. Some were big and very efficient and effective, others were small and unattractive. And we determined at the point that we needed a very dynamic and a creative manner of ensuring that the state is able to put some of its best resources where they are needed most. It was against that backdrop that we came with, the local government single public service bill, when we had challenges with the collaboration that we're having at that time with the Department of Public Service and Administration. But even then, we're working very closely with the Department of Public Service and Administration. Your various constitutional amendments, for example, that dealt with changing, how we demarcate provinces in terms of magisterial districts into using the municipal model. I drafted and led that process as a senior manager in the then Department of Provincial and Local Government. The ancillary bill that went with the 12th amendment, the redemarcation bill, as a senior manager in provincial and local government, I was also the lead person there. So one of my key strategic responsibilities was precisely to deal with that issue of policy and legislation, which at the time I did. In respect of justice, for example, so we draft the bill, engage the president and the minister at the time, and allow the relevant department, once the bill is prepared, to table it in parliament. But the person who will be drafting it will be myself from the Department of Provincial and Local Government. And I can make another example. With your SIU Act. At the time, I was on your SIU governance committee. We didn't see the efficiencies that the country at the moment is taking benefit from. We are the ones that actually advised for the gazetting of the SIU tribunal and the capacitation thereof. It is as a result of those interventions that we are now able to see the efficiencies in terms of pushback on corruption in the country, driven by the Special Investigating Unit, by Justice.
Just to do a follow-up on that one, because I do find, so you are saying to me that the responsible departments, such as Justice and Constitutional Development, abdicated its responsibility in drafting the legislation and gave it to the Department of COGTA in the 12th Amendment of the Constitution in 2005.
No, Minister. That's not the proposition. My submission is that we review the system of government as the Department of Provincial and Local Government. We would, assess the efficiencies or inefficiencies amongst the different spheres, and the developmental or the vision, of the state in terms of where it might want to go. For example, with cross-boundary municipalities and the challenges which that presented in terms of the provincial model, we had to look at that. Even the question of whether we should be having 9 provinces or 5 provinces or 6 or 4 provinces, we would have to look at that. But constitutionally, the executive authority that deals with that issue would be the Minister of Justice and Constitutional Development. So once we review the policy model, we draft the legislation, we'll then sponsor, the appropriate interactions between the appropriate executive authorities, so that if there's cabinet consensus, then the Department of Justice will be running with the relevant bill.
Okay, can we agree that you submitted inputs in the policy? Because you can't be the drafters of the bill, because in law, it's delegated to Justice and Constitutional Development. Otherwise, it means that amendment was illegal in terms of law. Because if you are the drafter, and you are saying to me now, sitting here as Minister of Justice and Constitutional Development, that the department, when they amended the Constitution, 12th Constitution, in 2005, they embarked on a illegal process of amending, meaning that I must go out of here and go and change that and cancel and review that because it was not done properly, procedurally.
No, that's not the proposition, Minister, and that's not how government works. The relevant authority, is the one that sponsors a bill in Parliament. And we know that the Constitution or constitutional amendments in terms of Section 172 would be facilitated by the minister responsible, which is the minister responsible for justice. But justice would not necessarily deal with the architecture of governance. That would be something that would be driven by the Department of Provincial and Local Government. So we would look at the policy, draft appropriate bills. So when you have sufficient consensus in terms of the direction that is deemed most expedient, we, as we did, would engage the Department of Justice to be able to lead the processing of the bill through Parliament. But at all times, of course, the relevant department would be the one that, whether you are appearing at the portfolio committee, for example, the constitutional 12th amendment was challenged right to the Constitutional Court. Even that process, we had to deal with it on behalf of the President and the Minister of Justice, even though they were, the main respondents going right to the Constitutional Court on those matters.
Okay, I'll leave it there. I won't pursue it any further. On number 5, you've listed various articles that you have written. Were they written directly by you or under pseudonym?
Where are you now, Minister?
On your questionnaire, number 5. Because I battled to find those articles.
Well, a cursory Google, exercise would be able to, because I've published in the, I've given, well, at least until such time that I started having one eye, as an aspirant judge.
Having? I missed that.
I'm saying I've published extensively in the Sunday Times, in City Press, in Sowetan, various papers. I've written opinions, but I then advised myself to step back because, I deemed it not appropriate as an aspirant judge to be, putting opinions all over.
Okay, thank you. Thank you, CJ.
Do you still want to ask your follow-up, Commissioner Baloyi?
It's not a follow-up, it's a different question altogether.
Then yours was a follow-up as well. Commissioner Mangen?
Thank you, Chief Justice. Good afternoon.
Good afternoon, Commissioner.
Yes. Mr. Kolong, I got a sense that you are trivializing the importance of the question that JP Tlaletse put to you in relation to the nomination. In reflection, do you want to answer that question? Who nominated you?
I'm sorry, I didn't hear you, Commissioner.
Should I start all over?
No, just the last bit.
Oh.
Who from who?
Who nominated you?
I've been nominated by Ms. Lamini and Mr. William.
Who prepared the nomination letters?
They prepared. the nomination letters. I provided the information as required. And I did so because they would not have the intricate details about my qualifications and experience. I had to provide that information so that there's coherence. And that I did.
And you gave them that information on the same day, on the 12th of June 2025, all of them?
I provided the information, Commissioner.
On the same day?
I provided the information.
I'm asking, on the same day, yes or no?
It would have been on the, day before, but of course there was a deadline, that they were looking at.
Fair enough. Let's get to your CV. The JP asked you a question with regard to your acting stint in North Gauteng. You'll find that let's go there, on page 20 of your bundle.
That's the questionnaire?
Yeah, the questionnaire, yes.
Okay.
Page 20, paragraph 8. Where
is it 8.1?
Yeah, where you made reference to 2004, and you said it's a mistake.
Where my page 19 has paragraph.
Page 20.
8.15. Oh yes, 9.2. I concede that's an error because from the CV and as you can see, Commissioner, the chronology of the various activities I was engaged in, quite evidently, I was engaged in the public sector at that point, so I couldn't have, an acting stint. So it was an error. I'm prepared to make that concession.
On page 22, paragraph 9.3.
I'm with you.
Yeah, you still made the same mistake?
Which paragraph is that?
9.3, where you referred to your acting stint in 2004. The point that I want to get to you is, how do you...
I don't see them. I just want to follow you. I see 9.2 on page 20. Where is the other error, Commissioner?
9.2. No, yes, 9.2 on page 22.
I only see 9.2 on page 20.
No, then we've got a different pagination. But the point that I want to get to you is, in your CV, you have made reference to your acting stint in North Gauteng in 2004 on 2 occasions, on paragraph 8 and on paragraph 9.2.
Oh yes, I see. No, that's a pure editorial error.
And it's surprising because you are a member of the Audit and Risk Committee and you appreciate the importance of the accuracy of the information that you provide to this body. Am I right?
No, correct, Commissioner.
Yes. It does not stop there. You say to the JSC, you have acted first term. And as a member of the Audit and Risk, you would appreciate the accuracy of the information. If you have acted for 2 weeks, there was nothing barring you from stating that I acted from the 22nd of January to the 31st of March. If it gives you 5 weeks, it would have been 5 weeks. But if you say a term, we know as practitioners, and you as an advocate, you know what a term is. Why do you state that you have acted for a term when you know for a fact you did not act for a term?
No. The question was, if so, please, I was giving information based on my interpretation of the question which was answered, Commissioner. So, as a matter of fact, I acted in the first term. And I thought the question was, do you have any relevant judicial or quasi-judicial experience? If so, please give details of such experience, including dates. And
Yeah.
it was on that basis that I gave the
No.
information.
No, advocate. Please give the dates of your appointment. An advocate who is a member of the Audit and Risk Committee, specializing in governance, would know and appreciate the importance of this question. Please give dates. What is it that you did not understand about it?
No, I see your interpretation, Commissioner.
The JSC accounts to the members of the public in terms of how it shortlists people and how they get to be here. It was on account of the information that you provided that I would want to assume that you were shortlisted, probably ahead of other candidates. Have you heard of the term embellishment of the CV or qualifications?
How is acting for 40 weeks embellishment of anything with respect, Commissioner?
I want to suggest to you that there is a misrepresentation of facts here. 5 weeks in a term is not the same as a term, as we understand it. Any comment?
Well, I've given my interpretation of the question and my answer, and I take your point and how you interpret it, Commissioner.
Thank you, Advocate. Thank you, Chief Justice.
Thank you, Commissioner. Commissioner Baloy, followed by Commissioner Pillay.
Thank you, CJ. Good afternoon.
Good afternoon, Commissioner.
Hello. If we could just go to your acceptance letter, and maybe before, let me just check this that I understand. You graduated in a BA Law in 1994. Is that correct?
Yes, Commissioner.
And your form says you graduated in LLB in 2000.
Yes, that's when I completed
And that's when
my
you
LLB.
were admitted as an advocate.
Yes, Commissioner.
Okay. So from 2000 to 2025, that's about 25 years.
Yes,
since
Commissioner.
you were an advocate,
Yes.
and since you were a legal practitioner as defined.
Yes, Commissioner.
All right. Now, in your acceptance letter, you're accepting your nomination. You say you were a legal practitioner, or you've been a legal practitioner for 29 years, 25 of which was as an advocate. Why is that?
Because I started as a legal advisor employed in the office of the Premier, and from the office of the Premier, I was employed as a legal advisor to the MEC.
Yes.
For environmental affairs and tourism.
Well, you see.
And from there to agriculture.
Yes, you see the Legal Practice Act defines legal practitioner as an advocate or attorney admitted and enrolled. So before 2000, you were not admitted and enrolled, and yet you count the period before that as a legal practitioner. What is? I'm assuming you know the act, you know the definition of legal practitioner. When you complete this form, why do you represent to the JSC and to the public that you've been a legal practitioner for 29 years when that is not true as a matter of fact and matter of law?
Well, I was a practitioner involved in the practice of law from 1996
Yes.
to date. It is against that backdrop that I put 29 years.
Okay. You accept the definition of the Legal Practice Act that I've given to you, that how it defines legal practitioner. You have to be an admitted attorney, admitted enrolled as an attorney and advocate. You accept that?
No, I accept that.
Okay, all right. So where your application, and it's not just in the acceptance letter, it is in various parts, including in your resume, where you describe yourself as a legal practitioner of 29 years. You accept that that's not correct. You've not been a legal practitioner as defined for 29 years.
And that was not the no. I'm prepared to make that concession, but that was not the definition I was working with.
Okay.
With reference to legal practitioner on my CV and the forms, Commissioner.
All right. And then at page 18, section 2 of the questionnaire, if you would go there, section 2, you have a question. If you just be patient with me, I'm trying to get there to that section 2. There's a question there which requires you to list the cases in which you appeared as an instructing attorney. That's paragraph 6.4. It says, list all reported cases in which you appeared as instructing attorney. You then correct it. You then type in, are you there?
Yes, 6.4, I'm with you.
And then you type in, I appeared as corporate counsel in the following matters. I've looked at those cases. Your name doesn't appear in any one of them. And one of those matters, the Matatiele municipality, which is matter number 4, Commissioner Pillay here was a junior to one of the councils. Now you've listed that you appeared there as corporate counsel. Why is that? And that is in all 4 matters.
Yes, like I said earlier on, I was the legal person in the Ekurhuleni Metropolitan Municipality and chief legal advisor in Ekurhuleni Metropolitan Municipality when we dealt with the issue. I was the one who gave instructions.
So you were the client?
No, I was corporate counsel in Ekurhuleni Metro.
No, I'm saying you were the instructing client to the legal team. As corporate counsel, however you define corporate counsel, am I correct to understand you that as corporate counsel of these institutions here or of these parties, you were responsible for engaging with the legal team that represented your institution?
Yes.
So it is not correct to say you appeared as corporate counsel in these matters?
I was corporate counsel, giving instructions to attorneys and counsel on these matters.
You do understand the language of the profession when we say I appeared in a matter as counsel. It means I went to court and I rose and addressed the court. I'm sure you understand. You accept that that's how we normally use the language.
Well, the question says as attorney. Attorneys don't stand up in court ordinarily with respect.
Yes, I'm not speaking to you as an instructing attorney. You corrected this form. You chose particular language. You didn't accept the language on the form. What you did is you typed in what you sought to convey to the JSC.
Yes.
And what you typed in is I appeared as corporate counsel. And it's for that reason that I went and looked. I read the judgment and I looked at who appeared in the matter, because you represented that you appeared in the matter. And it does say at the bottom of the judgment, appearances. So you and I know and understand what we are conveying when we say I appeared in the matter.
I see your interpretation. That was not the intended.
Okay.
Yes.
All right, thank you, CJ.
All right, I'm afraid we have to break for some time. Our litigation committee has an important commitment they have to attend, which they cannot miss. And it is lunchtime in any event, so we might as well take this time to break for lunch. 45 minutes should do. Come back at quarter to two. Lidcom would have finished their business and we would have eaten, and you can carry on until we finish. We are not done with the candidate. We'll finish with the candidate after lunch. Unfortunately, that's the problem.
Thank you, Chief Justice.
Who was dealing with him? You had just finished. All right. Thanks for the reminder. Commissioner Pillay?
Thank you, Chief Justice, and thank you for the indulgence, Chief Justice, for the litigation committee. Good afternoon, Mr. Kolong.
Your mic?
Good afternoon, Commissioner.
Mr. Kolong, I'm conscious that you've been shortlisted for the Limpopo division. So you're coming back before this body next week, Wednesday or Thursday.
Yes, Commissioner. I've been shortlisted for Limpopo as well.
And it is against that backdrop that I need to put my concerns to you. And my concern is that the interaction between you and JP Tlaletsi to start off with, and later between you and Commissioner Mangena, has compromised your integrity. And I'd like you to comment on that. But before you do, let me put my concern to you in no uncertain terms. When JP Tlaletsi initially put to you the similarities, the obvious and glaring similarities between the two letters, when he put that to you, had you answered Mr. Kolong by saying, look, I did that, I provided them with the two letters, it was an error of judgment. This body could have easily forgiven you for that. But what you've chosen to do, you've chosen to answer the question in such a way that it is absolutely clear to all of us sitting around the table that your answer, and I really need you to respond to this, your answer borders on being dishonest, in fact, if it's not completely dishonest. And I'd like you to answer that.
I note the comment and the concern, Commissioner. Perhaps that question ought to have been answered, I think, more better, for a lack of a better word. The fact of the matter is, I provided them with the information which led to the drafts that we now have before the JSC.
Mr. Kolong, I'm going
I
to
think
put
that concession I'm prepared to make.
It's not even sufficient, because I'm going to put to you that that's a false answer. So while you've been answering questions from other commissioners, I've had to spend my time comparing those two letters word for word. And this is what you pick up, Mr. Kolong. You pick up the same wording except for one line, which the later letter has, which the earlier one doesn't. One line. Everything else, every word used is identical. Every punctuation mark used is identical. The font is identical. The color of the font is identical. So there's no way that two people could have independently drafted the identical letter in the identical way and then furnished you with those letters.
Yeah, the simple reason for that, Honorable Commissioner, as I say, is that with the quality checks, you know, I assisted them with the information to make sure that the quality that comes ultimately to the JSC is good quality. I think that's where then the resemblances come from. So I'm prepared to make the concession that I was involved in the information provision and making sure that the quality that comes out is the same quality. I did not think that it would amount to, you know, an issue that should cause concern, because the fact of the matter is they were mindful to make the nomination, agreed to the nomination with enthusiasm. And perhaps it is that enthusiasm that might have compromised me. in ensuring that the quality that comes out comes in. I'm a stickler. I'm a stickler for quality. You know, of information that has to do with me. So it is against that backdrop that I provided the information in the manner in which I did, and it is against that backdrop that the letters look the way they do.
You see, Mr. Kolong, it's not your enthusiasm that has compromised you, but it's the dishonest answers you've given in the course of today that have compromised you. Can I just go on to the second issue? And you're saying that you're a stickler for detail, as I understand you. Is that correct?
Yes, generally I am. But
Now-
I must, also make the concession, Commissioner, that during lunchtime I noted the editorial errors, such as those that were canvassed earlier on. Those were pure editorial errors, and for that,
Those are editorial errors in your application form.
yes, like reference to 2004 as opposed to 2024. I regret those errors. I think with, it's just a hand typo in effect, and I regret that.
And your judgments, the grammatical and editorial errors in your judgments, what's your explanation for that?
No, I hardly have any editorial, what is it? There's one from the comment which I got, about reference to, calling one judge a he as opposed to, I think, a she. I think that's
That's
the one.
the Prudential Authority judgment.
Yes,
a
that's
comment
that,
by the GCB. Yes.
Yes, that's the one mistake that I note.
And there were few typographical errors in that judgment.
No, I agree, and sometimes that happens because one is pressed for time, and one, in as much as you try and sleep on a judgment, you wake up the following day, you put it aside, you come back, you'll miss an odd number or an odd, but for the most part, it doesn't happen. But I note the error that I made in that Prudential Authority judgment, and I regret it. I think.
And the rape appeal judgment, State versus Velasi, that judgment is riddled with typographical errors.
No, I make that concession. It's a learning. As a novice, sometimes when you are enthusiastic and you try to push out work, you miss the trees from the forest at times, and it happens. And of course, from this exercise, one learns to improve and make sure that there's minimization of unnecessary editorial errors.
Thank you, Chief Justice.
Thank you, Commissioner. Just to add one detail to the first part of the first of Commissioner Pilay's points, I want you to hold pages 1 and 6 of your documents. Page 1 being the first page of the nomination signed by Ms. Lamini, and page 6 being the page where you signed your acceptance letter.
Um,
1 and 6 in Koki, marked in Koki pen.
One that I have here is
Page 1.
Saula.
1 and 6.
I'm there, Chief Justice.
Am I wrong that they look like the same document? They look exactly the same.
Yes, indeed, because like I've considered, I was central in making sure that the quality of the nomination and the acceptance and the information that comes out
No,
is the same.
that was in relation to your nomination letters. Now I'm asking you to compare a nomination letter and your acceptance letter.
Yes.
Which is a different issue altogether. Yes. Would I be wrong in assuming, therefore, that the nomination letters and your acceptance letters were produced from the same device?
Yes.
Also, you've already considered that?
Yes.
Oh, sorry, I missed that. I thought you were talking just about the nomination letters.
Oh, okay.
Okay, so they came from the same source?
Yes.
Okay, thank you. Commissioner Kane?
Chief Justice, I think we're nearing what's necessary, but I just need to put this to the candidate. So if you would have a look at page 18, you've given a list at the foot of that page of some 15, sorry, it runs right to 22 positions that you hold on various boards. And it seems that it's predominantly finance-related, audit and risk committee type appointments. Now, these audit and risk committees, as far as I know, having served on one, involve a substantial amount of work. You get a pack, you get the audited financial statements, you get preparatory financial statements, you have to oversee the auditor's work. You're then also in charge of risk. So you'll agree with me, it's an onerous responsibility, am I right?
Yes, Commissioner.
How many of these boards did you serve on, let's give an example, in 2024?
In 2024, if you go to my CV.
You can give it more or less. I'm not going to quibble with details here.
Yes, I was involved with the Independent Electoral Commission. I sat on that governance audit and risk committee. The Free State.
Can you not just give an indication?
Three.
You must know for sure.
It was 3, Commissioner.
3 in 2024. In
Yeah.
2025, at this point, how many of these committees are you on?
3.
3.
And by the way, legislatively, the guidance that is out there now is that, you cannot sit on more than 3 at a time, for the same reasons that you are putting forward.
Yes. You see, I have some trouble then if you're serving on 3 in a year, and these committees would no doubt meet regularly, at least 4 times a year, and you have a pack to prepare with, and you then have the other meetings involving the relevant executives and the auditors. I have trouble in understanding how you also conduct a full-time advocate's practice.
Yeah, that's why, Commissioner, I see it as a contribution to my country. The amount of time that is involved, as you say, are quite onerous. The documents you have to go through, the time you have to expend, and the stipend, it's really a contribution. And it is something, I am passionate about, driven more by being able to make a contribution in whatever little way I can, so that our country is better off and is able to move forward. And I hope that more people, with the challenges that we have in South Africa, would be mindful to can sacrifice some time and make a contribution so that the country can develop, so that we can reduce the unemployment rate that we have, fight corruption, improve efficiencies, so that ultimately
Sorry,
we
sir,
have a
I'm
better
going
country.
to stop you because I know that we're running short on time and not out of disrespect. I asked a question, you didn't answer it, and I'll leave it at that. Thank you, Chief Justice.
Thank you, Commissioner Kane. Is there someone I've left out, colleagues? Commissioner Trollip, followed by Commissioner Kotsel.
Thank you, Chief Justice. I'm partly covered by what Commissioner Keynes just asked. But Mr. Kolong, you've said that you have a passion for Audit and Risk Committee and that you want to make a contribution to your country. You serve on multiple organizations, institutions, even governments. Many of those have parlous audit outcomes. I just went through a number of them that you listed there. They really have quite shocking audit outcomes, and some of them are renowned for being really bad. Is that a matter of concern for you?
No, it's a matter of great concern to me, Commissioner. That's why in our annual reports, we'll be mindful to, where appropriate, advise Parliament, because Parliament ultimately provides resources and would require accountability in terms of performance and accounting for the resources that have been expended. So where we identify exceptions of concern after getting the reports of the Auditor General, for example, would be mindful to ensure that not only do we engage and seek to push the leadership and management in those institutions to improve, but as part of combined assurance, ensure that the legislative arm of government is made aware of the challenges and where those challenges sit, so that they can be able to drive change and improvement in those areas where they're concerned.
Thank you, Chief Justice.
Commissioner Kotsel.
Thanks, EJ. Mr. Advocate Kolong, good afternoon.
Good afternoon, Commissioner.
In your questionnaire, you apportion 15% of your entire career's work to criminal work. It says criminal litigation, 15%. Is that correct?
Yes, Commissioner.
All right. So I just want to understand, you acted in the High Court in the Western Cape in the third and the fourth term last year. Sorry, third,
Yes,
fourth,
Commissioner.
and first term, and you said that you've been to Thembalethu Circuit Court 3 times.
Yes, Commissioner.
That's in George.
Yes.
Do I then take it that you've gained some experience in the criminal court?
I've gained a lot of experience.
How many trials have you done?
I've dealt with criminal reviews, criminal appeals, sat on a full bench in respect of a criminal appeal.
Yeah, no, I got that because you did inform the CJ earlier. My question is, how many criminal trials have you sat on?
Well, I've not sat on a criminal trial precisely because in the nature of trials, they tend to take a long time, longer than one's term. And when of course, I had keen interest and engaged the leadership in the division when I acted. You have to deal with the matters that are allocated to you with a view that when your term ends, you don't have party-head matters.
Yes, I'm familiar with that, but I mean, you served 3 terms. But can I just ask what matters you attended to in Thembalethu then?
Well, I dealt with divorces, a number of interlocutory applications, civil trials, a lot of civil trials. You know.
Okay, so general civil work.
Yes.
And I just want to understand your acting stints in the Western Cape. How did those come about?
I was invited.
By whom?
By the division.
By whom in the division? You said earlier you should engage with the leadership. Who was the leadership at that time?
I was invited by the judge president of the division at that point.
Yes, who was the judge president of that division at that point?
Judge Goliath.
Judge Goliath. In the 3rd and the 4th term last year?
Yes, Commissioner.
And then again in the 1st term this year?
Yes.
All right. Thank you. Thank you, CJ.
Thank you, Commissioner. Is that everyone? All right. Thank you, Mr. Is it Holong?
Thank you, Judge. Thank you, Chief Justice.
advocate now. Advocate Mokhosi.
Good afternoon.
How do I address you?
It's a difficult one. CJ, I think even Mohot is still fine.
Okay.
Or even my first name, it's still fine if you can.
You hold a few law degrees, a BProc, an LLB, and 2 master's degrees in law.
Correct, Chief Justice.
And you started out as a public prosecutor, then became a magistrate, where you spent a substantial time. You were a district court magistrate for 10 years, and then a regional court magistrate for 26 years, says your application form.
Correct, Chief Justice.
And now you are working for the NPA as a senior state advocate.
Correct, Chief Justice.
Since when?
I think it's since May 2023.
Right. You have acted as a judge.
Correct, Chief Justice.
In Pretoria and Johannesburg. And I see that you started in 2013 and you've acted intermittently until 2022.
Not exactly, Chief Justice, because I omitted to also state that I did act in 2023, the first time of 2023. In other words, I think from that document, you'd say I acted for 64 weeks roughly. But when in actual fact, I've acted for almost a minimum, I would say a minimum of 75 weeks, because those weeks do not include my acting during recess, because mainly I would still act during recess, but I would in the main be doing my partly heads. So I didn't deem it necessary to state that I acted during recess because it's in the main partly heads.
All right, so you count about 75 weeks in all. You mentioned 75 weeks.
Yes, Chief Justice.
In the Gauteng division?
Both divisions, Chief Justice.
Okay. And you've also acted as an assessor in the High Court?
Yes, it was, I think, I'm not so sure, but it was around 1990, could have been 1996, 97, when I was called by the the then Uputatswana Judge President to come and act as an assessor there.
Well, you mentioned that you did not give a precise account of the the terms you've acted, because you say you lost your laptop. You don't have access to accurate information, and I was asking myself why you did not approach the division where you acted and ask them so that you give us precise information.
Chief Justice, I did approach them, and particularly the Pretoria division. And they said to me that they don't have the kind of information I was looking for. I remember I did that telephonically, and I remember speaking to, about 2-3 ladies over the phone who said ultimately that no, they don't have the kind of information I was looking for. But it's not only that I lost my laptop, it's because of, I don't know whether I should go there or I should wait.
Well, I don't know what it is you wanted to say.
I could not, you see, the time frame did not allow me to do all what I wanted to do, because I got nominated, I think, on the 10th day of June. And I've subsequently written to say that, to state clearly that I got nominated almost, I can say 48 hours before the closing date. And in my nomination, I mean, in my supplementary document, I also said that the reason why I could not write these things in detail, it's because of the time frame, firstly, but secondly, because of the fact that the 10th day of June is the day on which my mother passed on. So as I rushed home to go and arrange for the transportation of the corpse, while still there, is then that I got a telephone call that I've been nominated, meaning I had to rush back now. And it's about 150 kilometers or so to come and complete the forms. And I had only less than more or less 48 hours to do all that, while still running the funeral and trying to collate the information. But I did, in short, in brief, I did phone the Pretoria division and ask for that. Not only the Pretoria division, I also phoned the regional, I mean the regional court manager, because I was also looking for further information from him.
But you are certain that the times you've given us are actually correct. You did act at those times.
I believe it's actually more because, like I'm saying, I tried to be conservative because I was there almost every recess. I was there. So I didn't include that. I really did not include that.
Okay. You've written judgments during your acting stints in the High Court?
Yes, Chief Justice, I did.
How many?
I did write judgments.
Oh, I thought you gave a number. Do you know how many?
I don't know, but
an estimate, maybe?
Like I'm saying, I on each occasion tried to finish the files I was allocated to. So I don't know how many, but there could be conservatively, I think they could also be close to 100 or so, because for all that period I wrote my judgments, and that is why even today I hardly have a partly head.
All right. And your application form lists 3 as reported. Is that correct?
I'm sorry,
your application form states that you have 3 reported judgments. Is that right?
I can say 4. It doesn't look like it includes one of the Northern Provinces Law Society versus the Heppel matter. It doesn't look like it includes the Heppel matter.
You list a number of courses and workshops, judicial courses and workshops you've attended throughout your stint as a magistrate, and I imagine as an acting judge.
Chief Justice, yes, but not all. These are just, because for 38 years, you can imagine, I attended many courses, but those I could just list out. But I attended many.
And you mentioned them because they enriched your work as a judicial officer.
Correct, CJ.
All right. All right. JP Mpahlele, do you have questions for this candidate?
Thank you, CJ. I just want to follow up on the question about the short notice on the completion of the form. That you saying there were time constraints because it was completed in June. But we got an updated form, which is dated September, 26 September, after the shortlisting.
Correct, Commissioner.
And I don't think it makes it any better, this form, because in the first one, it was not very clear of how long to act. And then now you just mention it's over a period of 7 years, and it could be misleading if you're saying over a period of 7 years, and you're still raising the issue of the laptop.
Commissioner, if I said 7 years, I don't. Then it's my mistake. I must apologize. I never said. If I said 7 years, it's my mistake.
If you can go to page 10 of your form.
Page 10 of.
Yeah, the form that's dated 26 September 2025.
Okay, let me quickly go through this. I'm still trying to locate it, but if it's 7 years, I can clearly say it's a mistake. Because I remember I acted for, remember it's from 2013 to 2023. But the fact of the matter is that I was not there all the time. For instance, 2017 to 2018 could have been around June, July. 2017 to say around about November 2018, I was the acting regional court president of the Northwest Province. So I wasn't acting. That is why I, at some stage, said intermittently interrupted periods of about 10 years.
Thank you, sir. Did you have sight of page 10 that I referred you to?
Absolutely.
Sorry, CJ, we're battling to hear JP.
Oh, my
You might
apologies.
repeat her questions.
Oh, my apologies. I was referring him to page 10 of the form dated 26 September 2025. And in that form, he's stating 9.2, it said please give the dates of your appointment. And the answer is there are many over 7 years. Then you give examples.
Yeah, and I see it. That's
You
a
see
typo.
it.
I must say it's a typographical. It was never intended to be 7 years.
It's a typo.
Yes, yes.
Okay, thank you,
It
sir.
was really, and I apologize for that. It was really never intended to be.
Okay. Can you just, on 9.3, because it's not clear, because this is a new form that we received after the shortlisting. On 9.3, can you just give a breakdown of your extincts? How much were, maybe estimation? Maybe how long, maybe per percentage in the civil code and the criminal code? You're dealing with it in 9.3, but it's not detailed.
Yes.
On the same page 10, sir?
Page 9.
10, the same one. After 9.2 is 9.3.
I am not going to be exact, Commissioner, unfortunately, but all what I can say is that, let me say, could have been 70 to 80% was criminal work, and maybe say 20% civil. And that is the reason why I don't know whether I should expatiate or not.
You are welcome.
Commissioner, this issue of not doing civil work then is the one which has been prejudicing me from the year 2000. I attended the first aspirant judges course in July year 2000. And I couldn't make it from 2000 because I could not be exposed to civil work. I got nominated, I think 3 or 4 times. I declined. My first nomination was in the year 2000 by Advocate Safas of Johannesburg Bar. I went to Cape Town, attended the course, but declined to take up the I attended the course, but declined to be nominated as a judge because I wasn't sure whether because of the number of civil work I had done then, civil cases I had done then, I wasn't sure that whether it was appropriate for me to apply or not. I then got another nomination, I believe it was around 2014-15, which I declined. I got another one in 2019 from the judge I was working with in Palm Ridge. I declined. And it was simply because of this.
Okay, thank you, sir. Just for the record, you don't have any reserve judgments now?
No. I don't have a partly hate. I don't have a reserve judgment.
You don't have a partly hate?
A partly hate in the High Court or a reserve judgment. I don't have any of those.
Can we go to this form of 26 September 2025 on page 11?
I'm not.
Do you have the form of 26 September? The one that you submitted recently?
The one your questions have been based on.
Yes, it's dated
I
26.
just can't locate it here, and that is why I've been using my but I don't want to delay the commission. Commissioner, is that page 11?
Yeah, I want us to look at paragraph 9.6 of the form.
Yes, Commissioner.
Saying, are there any partly held matters which you should bring to the attention of the commission? You marked yes. If so, please finish particulars. Case number 50/2020, State versus IV Baloyi.
Correct, Commissioner. I mentioned it. It's
But
correct.
you just said you don't have partly held matters.
Yes, Commissioner. What happened is, as at the time I was completing this form, I was left with one case where I had to sentence. It was postponed because the defense wanted a pre-sentence report. Now, like I'm saying, I don't want to disturb the High Court's role when I'm acting. I only do my partlets during recess. So immediately when they went on recess, I went there and sentenced Commissioner.
Okay, thank you. Thank you, it's noted that it's now finalized. Have you ever encountered with the Mpumalanga High Court Division?
No.
Never.
I'm sorry?
Have you ever encountered, any encounter with the High Court in Mpumalanga, whether in Mbombela or Middelburg?
No, Commissioner.
Okay. Thank you, CJ.
Thank you, JP. Premi?
Thanks, Chief Justice, and greetings to Advocate Didi Mkhozi. Do you know the province called Mpumalanga, a rural province in South Africa?
A rural province. I cannot say I know Mpumalanga because when I say I cannot say I know it. I usually go there. I do go there. I go to Middelburg. I go to like Nelspruit, Coronation Park. But speaking about the rural areas, the better part of my serving as a magistrate was in the rural areas. And actually, if you allow me, Commissioner, if you allow me, actually,
No, it's fine.
I'm sorry.
I think I understand your response that you once worked in a rural area, like Mpumalanga.
Yes,
Then I will want to know
yes, if
you
I may,
understand
okay,
access to justice for all, especially in a rural area, the challenges,
yes,
as well as what you think that we can be able to do to deal with these challenges.
Correct. Commissioner, if you look at the number of years I spent as a regional court, as a magistrate, and you go through my CV, you'll immediately pick it up that I was mostly working as head of court. And you also realize that you'll realize that there was a stage where I was a chairman of case flow management committees. Now, in an effort to fight backlogs, because this is, sticking out like a sore thumb, the backlog cases. I then came up with this thing because in the rural areas, for instance, where I worked, you would get the previously disadvantaged people traveling by bus, leaving their areas at 3 a.m., and it's only one bus per day, and they'll reach the court at about 5:30, 6 in the morning, and they'll go back perhaps 3 o'clock when we are still busy with the witness. That witness must go back home. It's only one bus. Now, in the case law management system or plan we developed, which I chaired, I then came up with certain proposals to deal with this kind of situation of rural areas where transport is a problem and so on. And amongst others was that instead of starting a court at 9 o'clock, the magistrates, if they can, should at least start at about 8:30 or so. And I did the same even when I was still acting the High Court in Pretoria. My court wasn't starting at 10 o'clock. I would start at 9 o'clock at the latest. And when I'm in the regional court process or the district court, I would not even go for tea breaks, if I can tell you, just to cater for those people so that they can go back home. Because in one area, I can tell you, a witness would just, if you don't stop, a witness would just leave the witness stand and run to the bus while still testifying. So these are the kind of situation one would want, or one wanted to cap as soon as it became a chairperson of case flow management, to say, let's deal with cases of scholars during school holidays. Let's deal with cases of the elderly, the cases of pregnant women first thing in the morning, so that we release them to go and catch their buses. But then we also tried to create periodical courts so that we could reach out to these people, because some of them were not working. Remember, there's a high rate of unemployment. So the minute they can't afford to come to court, and remember also that, for instance, if you look at Garankuwa is geographically in Gauteng province, but for all intents and purposes, for the better part of the time, it was falling under Northwest. So you encounter a problem about police officers transporting witnesses. They would tell you that, no, we don't have enough vans and so on. So we tried to reach out by arranging that we go for periodical courts. We would group these villages together so that we go to them, because if it's us going to them, it would be the three of us going there rather than expecting the whole bus to come there. And if you go to them, you cap this situation where a witness would want to leave a witness stand while testifying so that he or she can rush to the bus. And I did not only end up there. Even when I was facilitating at Saji, we would go around the country, maybe the three of us, because it works out cheaper if we go around to train presiding officers rather than them flying over to, say, Gauteng province. So creating periodical courts was one of those means of accessing people in the rural area. And I must say that for the better part, as I was serving as a magistrate, what I used to do is that I actually served in all the courts of Northwest, all of them. So what I used to do is immediately when I go to this office, which would be a new office, I would take a car around so that I can quite understand my jurisdiction. And back then, I would also liaise with the traditional leaders, talk to the traditional, just get a feel of what's happening there. So that when I'm sitting back in the office, I know what's happening in my jurisdiction. I know the problems. Like I'm saying, in one area, there will be only one bus. So that is the kind of information which used to assist me to fast track cases and to get to understand how to deal with particular cases. For instance, those who are coming, who are locals, I would then deal with them after I have dealt with those who are coming from the far-flung areas. And I remember even when 2013, when the Chief Justice, when the Judge President of Gauteng wanted to call me, that was my first acting stint. I didn't know him. I remember I was in court at around 5 o'clock because I was still dealing with these people who are locals after I have dealt with cases of those who are coming from far. And he said to me, I've been calling you, and it's now 5 o'clock. What have you been doing all along? And I said, no, Judge President, I've been in court trying to dispose, it was during school holidays, trying to work on cases of children who are attending school, because this is the only time I can access them when schools are closed. So I try to categorize cases, and I try to reach out to each and every case, because I have this in my mind that when we deal with cases, it's not sufficient more often than not to say, I have a lot of work. I believe you should deal with each case as if it's the only case, even though you have many cases in front of you. So that has been my approach. I'm not succeeding in that regard, but that is what keeps me going.
But if you may be successful on your application, what will be your area of priority?
My area of
priority, the priorities that when you are appointed, you will have to pay special attention on. Immediately you received your appointment letter, the first time that you arrived in your office, what is it that you are going to concentrate on?
Before I can even go to my office, if I'm appointed, I'll do what I'm used to doing. I'll take my own vehicle, go around my area of jurisdiction to understand my area properly. But back to your question. As soon as I take up the office, one thing I have noticed with Mpumalanga, though I haven't acted, I get an impression that there's a need to be firm on this issue of case flow management. The first thing I would do if I get appointed would be to look at the number of cases enrolled, actually look at how they conduct the pre-trial conferences. Because what I've seen from far, I might be wrong, Commissioner, I might be wrong, but what I've noticed from a distance is that the number of cases they enroll, they do not necessarily go through the court system. Some of them get withdrawn because they are not trial ready. So back to your question, if I get appointed, that is the area I'm going to start with. To be firm on what is undertaken during pre-trial conferences, to be firm on the question of enrolling cases which are trial ready, and to ensure that all the cases which are enrolled for trial are of course trialed. And this I learned from, we had a case flow management, I think in 2013 in Mokopung, which was hosted by the then Chief Justice, where we were addressed by the Chief Justice of Malaysia, where he said, amongst other things, that they only postpone if there is a death case. If there's no death case, they don't postpone. In other words, they ensure that whatever matter is enrolled is proceeded with. So that would be my starting point, Commissioner.
No, thanks, Chief Justice.
Chief Justice, can I follow up? Thank you, Mr. Mohosi. I want to follow up on the question that was asked by the Premier when he asked you as to whether you know Mpumalanga. I didn't get an answer there, but you just gave us a background of what you did in the Northern Province, Northwest. We wanted to know as to whether do you understand the dynamics of Mpumalanga as a rural province, the province that you want to go and serve its people. Do you think it's fair for the people of Mpumalanga to go and serve them if you don't even understand the dynamics of that province, let alone the High Court? The JP also asked you about whether you've been to the High Court of Mpumalanga, and you said no. Can you comment on that?
I thought I've touched on that, Commissioner, but I'll go back to it, Commissioner. I said, if I get appointed, I will, at my own expense, because that's what I'm used to doing. I'll go there and start rounding up the area, looking at the jurisdiction and so on. And I think also, if you look at my, although it's not reflected in my CV, also said, I give an example by saying I also worked in the whole of Northwest. I wasn't used to those areas, but I worked in all those offices because immediately when I get transferred, I used to be transferred, I got transferred to all those courts which are in Northwest. I would round the area just to get a feel of what's happening, to know the problems, so that when I'm sitting in my office, I know what's happening where. But also, it may not be 100% correct to say I don't know Mpumalanga. It should be remembered that parts of Mpumalanga, like Marapshan and so on, used to fall under, I think it's Northwest also. So there are areas I know, and there are people I know, and I do visit Mpumalanga. So it's not like I don't have a slightest knowledge of what Mpumalanga is. I don't have a slightest knowledge of the far-flung areas of Mpumalanga. It's not like that. It could well be that I don't know many areas, but I know parts of it. I have families there. I know what's happening there.
Thanks, CJ. I leave it at that. Thanks.
Thank you, CJ. Good afternoon, Mr. Mokota.
Afternoon, Commissioner.
I'm here. I've got a slight problem with the questionnaire that you submitted in your application. How did it come about that you completed the wrong questionnaire?
I have Commissioner, let me try and reiterate because I sketched out a background. I said, although I got nominated more than 2-3 times and I was declining, this time when I got nominated, it was immediately after I was busy trying to arrange for my mother's corpse to be transported to the mortuary when I received a telephone that I'm nominated. And I said I had less than 48 hours to complete the forms. And honestly, I wasn't in my sober senses because of what was happening there. And that is why I committed this mistake. I can even submit that certificate to show you that I was in that state of affairs when I had even less. If I knew that I would be nominated, because people approach me and I've been declining all along. It's not me who approached them. So if I knew that I would be nominated, I would have acquainted myself with forms long before then. So by the time I experienced that, I did not even know that I'm going to be nominated. And when I got nominated, I was in that state of affairs. And in that state of mind, I then completed a wrong form. I wrote in the amendment to apologize for that mistake, Commissioner, and I'm still apologizing even now for doing that. It wasn't intentional.
All right, thank you, Mr. Mokota. Okay. But you understand now the problem that it created because you were assessed on the basis of the information that is contained in a wrong form. Hence, the complaint or the concern of the GCB that they were unable to assess you sufficiently because you finished them with the wrong form. So some information was missing in the form that you submitted.
Commissioner, thank you so much, and I accept that. Even if I'm prejudiced, even if I'm not appointed because of that, I will accept that, Commissioner, because I did not do that out of my own. I wasn't really, because when I was busy here, I had to travel, like I said, 150 kilometers to come and complete the forms, the original forms. And back home, they were still phoning me to say, but where are you? Because we are faced with this problem. So, and I had less than 48 hours for that matter. So if this situation prejudiced me to the extent that I can be appointed, I will accept it, Commissioner.
Thank you, CJ.
Advocate Mokhozi, your CV states that you are currently contracted to prosecute truth and reconciliation cases. on behalf of the NPA. How long is that contract, may I ask? When does it terminate?
The contract is such that if any or either party wants to terminate it, we should give each other 2-3 months notice. But in any event, it's coming to an end early next year.
Early next year.
Yeah, but if
when next year?
It's probably going to be February.
All right.
But if any party wants to terminate it, you just give notice and you terminate it.
So if you are appointed next month, you would terminate your contract with them and leave things unfinished there, you say?
CJ, if you look at my nomination, the people who nominated me are from that particular sector. They said I've worked with them and they feel that I don't belong there. So once they said I don't belong there, I must go elsewhere. I think if I go to them and say I'm appointed, they will gladly release me because they are the ones who said they feel that I'm underutilized. It's not me. Like I said, these nominations, I wait for nominations to come. So if it comes to a situation where, for instance, I get appointed, it's fine. I think they will release me.
So are you saying you're not gainfully engaged there? You don't have enough work to do?
No, I have work to do, but they were saying my knowledge and experience, it's such that it can be utilized somewhere. Underutilized, not in the sense of the number of cases. Underutilized in the sense that I should serve elsewhere in a different capacity, let me put it that way. But there we are having a lot of work to do. CJ, let me say that there's a lot of work to do. Remember, we're dealing with cases where you don't even have a docket, for instance, more often than not. We're dealing with cases where you don't have original statements. But we have now started to prosecute. There's movement there, despite the fact that the documents are missing. There's movement there. So for one to deal with a matter where there's no paperwork and still take the matter to court, it shows that there is work, there is a lot of work being done there.
But they say your skills and experience are wasted there.
No, they are not saying, maybe I used the wrong word if I say it's wasted, if I said it's wasted.
That's the impression I have.
No, they are saying, society can gain better if I'm utilized in a different capacity. But they are not saying they don't want me. I can tell you they really, I'm working with them and we are working well. And I'm contributing and they're happy with what I'm doing.
You will turn 68 in December 2025, not so?
Correct, CJ.
How long would you have to serve as a judge if you are appointed?
CJ, even beyond 75, I'll be active for a number of years. But remember, if I get appointed, I'm still going to serve beyond that. And for me, Chief Justice, what is much more important is not exactly the number of years. What is very much important for me is the mark one is making, the difference one is making. If I'm able to make a mark, for instance, the reason why I was declining the nominations amongst others is that if you look at one of my masters, I did a masters in human rights. And these issues of transformation and gender equality and so on, I'm aware of them. And that is why even when I was declining to be appointed as a judge, I enjoyed myself to train those who will be judges. And amongst them, obviously, there were ladies, our black ladies, and so on and so on and so on. So I was contributing in that regard towards transformation. So if I get appointed now still, the issue is the mark. The issue is the dent I will make. But beyond that, I'm prepared to serve for even if it can be 8-10 years. I'm very much prepared to serve after 10 years. But in any event, after being active, I would still serve as a retired judge should I be appointed Chief Justice. There's still energy. It would be different if I was not quite healthy. If I was quite healthy, it would be something else. But as it stands now, I'm quite healthy. And that's what I'm saying. My projection is that I'm going to serve for as long as it is possible, even if it's beyond those 8 years, even if it's 10 years, because my aim is at least to be active for the next 10 years and beyond if it's possible.
Minister?
Thank you very much, CJ. Good afternoon, Advocate Mkhotsi.
Afternoon, Commissioner.
I'm a bit worried about your comment as Minister responsible for those issues of TRC. Are you saying the work that is being done in collating, because we understand the context of having to deal with reconstructing evidence and all that, and you are saying it's fine, you'll be able to leave site. You said, how long do you have to give notice? Are you not having a case active now in the work that you are doing?
There is, Commissioner, we are working as a team. There is a case which is active now. We are working as a team because what happened there is that we acknowledge the fact that these cases are quite old, the witnesses are passing on, the accused are passing on. So we don't work as individuals. The situation is such that even if I'm here and the case is before court, that case will run in my absence. If it's a question of arguing, we sit together, hold a meeting, draft a document, and one of the counsels would go and argue. So we work as a team, and that is why they are saying, and in any event, they want to do away with these contracts because there's no money any longer. They would want to employ those who would be permanent there. But for now, we work as a team. So even if I'm not there, and there will be those who will be going on with the work.
Okay. The second question I want to ask, if I'm correct based on the questionnaire, and I'm mindful because it was saying that there's information missing. So you last acted in 2022 as a judge.
Commissioner, I said according to the form 2022 years, but I acted until the first term actually of 2023. I was acting, and like I said, I had a partly head matter. I was in court in the High Court. Was it 2 weeks ago or last week? The first week. I think it was the 1st of October, so if I'm not mistaken, around that time. I was on the bench. But my last term was the first term of 2023.
Or you acted now in this, you said the last time, between 2024, 25, did you act?
2023,
the reason, maybe let me contextualize. I'm trying to understand. So you acted, you stopped acting because you took the responsibility in NPA, or you continue to act as a judge while you are on NPA?
Thank you, Commissioner.
As a contractor.
Thank you, Commissioner. What happened is, I was active in the High Court until the first term of 2023. So I acted for the full term of 2023. And around May, then I was then called to come and work there at NPA. So I've been with NPA since then. But then I had partly had like this one of Baloyi. So each time they're on recess, I would go there to deal with this matter. So until, like I said, I finalized it, was it a week or 2 ago? So if I go to court from 2023, it would have been mainly to finalize a partly head matter.
Or to finalize a matter that you were dealing with?
Which I started when I had a term, when I was appointed, that is, for instance, around 2023, 2022, 2023.
Okay. No, thanks. I think I wanted that clarity because I was worried about you being in the prosecution side and being a judge as well, because for me it does give that.
Yes.
Yeah, it's worrying, because
I-
even where I'm sitting, we could have handed over the matter back to somebody, but for you to still continue to sit on the bench while you are appointed by NPA, it's doesn't come across as
Yes.
correct where I'm sitting.
Correct.
I don't know if both parties were aware. Was NPA aware that you continuing with the matter in court, and was the judge president of that part? Was it Gauteng?
Yes.
Was Judge President in Gauteng aware that you are appointed by NPA on contract as a prosecutor?
I don't remember informing the JP, but I remember talking with the DJP about it because let me sketch this to you that it wasn't like I'm starting new matters. I never started any new matter ever since I got appointed.
No, Advocate, it's not about new matter, it's not about. Remember this institution in terms of their responsibilities. They must be independent of each other.
Yes.
Yes, that's why I'm asking if you disclosed to NPA that you currently have matters before court that you are still attending to while they appointed you as a Section 38. My assumption is that you are a Section 38 appointment. And similarly asking if the head of court where you were dealing with the matter was aware that you have been, because he would have appointed as an acting prior to you, as you say, prior to you being appointed in 2023 in May by NPA to deal with a prosecutorial matter. And that's what I'm asking, because there are issues here that we should be able to deal with. And if neither of them did nothing about clearly an issue that they should have attended to.
Yes. Thank you so much, Commissioner. I'm well awake to this issue of separation of powers. I'm well awake to this issue of the three arms of the government having to work independently from one another. But let me say that it's my mistake that I did not make the JP aware of that fact. I thought because I'm just finalizing an old matter. It's very much unlike if I was going to start new matters. I thought because and it had gone very far. So I thought because it's just finalizing it won't affect that kind of a situation. But I must say, Minister, that I'm awake to that issue of separation of powers, and that is why I never took up a new matter, and I never even requested to act whilst completing this partly head.
Thank you, Sir.
Thank you, Minister. JB?
I want to make a follow-up. I heard you having good suggestions and your concerns about the case flow management in Mpumalanga. Had you had an opportunity to go through our practice directives and see how we deal with case flow management, both in the civil court and the criminal court?
Yes, JP, I did. That's what I'm saying. I don't have personal knowledge of what I said, but that is what I don't know where did I get it, but as I was reading, it's something I came across it. But like I'm saying, if I get appointed, it's obviously my duty to go back and read these practice directives. But that is what I casually saw, and I thought perhaps it's something which I could start with to assist the senior managers as soon as I get there.
My question is, did you read the provisions dealing with case flow management? Because now you're making suggestions as if those provisions are not there, or not adequately dealing with the issue. So that's my question. It's either you had sight of it or you did not.
I had sight of it. The problem, what I was alluding to, it's that it's not that those provisions are not there. it's complying, it's lawyers complying with the provisions. I'm aware that the provisions are there. Even now in my bag, I have the practice directives with me now. So it's here underneath the table. They are here with me in the bag. So I'm aware of that, but it's an area where I realize that even though the management is doing their best, it looks like other parties are not coming to the party. So that's why I said that is one area where one could perhaps assist. Not to say the provisions are not there. I'm aware that they are there. I'm aware that the managers are trying to solve this situation, but I see that it needs further attention.
Yeah, but it's not attended to by the managers, but we leave
No,
it
no,
there.
no. No, with due respect, I can't say that. I can't say it's not being attended
No,
to.
no, I'm saying it's not the managers who are attending to the issue. I'm just correcting you.
Okay.
And the practice directive is very clear. It's not the managers.
Thank you,
Thank you,
thank you so much, thank you so much, thank you so much, I'm sorry if I said something which is untoward, but that is one area which I thought perhaps we could address if one gets there. But
Commissioner Ngwetho.
Thank you, Chief Justice. Advocate Mokgotsi, did I understand you correctly when you answered the Deputy President that the reason you ended up completing the wrong form was because you had to come to Johannesburg and complete it and you had a funeral at home or a bereavement at home?
I don't remember saying Johannesburg.
Okay, well, it doesn't matter where you completed it, but you traveled an hour and 30 minutes.
Yes.
But what was the reason?
What was the reason?
Yes, why did you complete the wrong form?
I apologize for that. I said I was not in my senses. It's a mistake. I was not in my senses because of what had befallen me. So I don't know. I wasn't really in my mind, you know. Like I said, I've just lost my mother, and I never foresaw it. And like I said, when I got a call, she was still lying there. She had to be removed. And at the same time, the deadline was just, I had less than 48 hours. So
Yes, that's what I want to ask. I mean, how long were these positions advertised for?
Subject to correction, I think it was from May, but I was not nominated then, and I didn't know that I would be nominated. So I couldn't have completed the form when there was no nomination because I'm not the one who approached people to nominate me. At all these material times I indicated, they are approaching me, and I don't know when will they approach. For instance, during 2018, 19 or so, I wasn't approached, and that's why I did not apply. So even this time, these posts were out there, advertised there, but I did not know that one day I will be approached. Someone will say, are you prepared to take up this? I did not know. And I only got a telephone when I was in that state of affairs. I couldn't have foreseen that I will be nominated. Otherwise, I could have completed the form long before then.
Right. I don't think you've answered quite. How long were the positions advertised for?
I'm not sure. It could have been maybe 5, 6 weeks.
Yes. All right. Now, then, when you finally completed the form, one of the points that GCB points out are the cases you've cited. I just want to take you through to them because I tried to track what they were saying about these judgments. There is a section where you must set out the cases that you consider to be significant, and it says not more than 10. The first case that you cited is actually a Supreme Court of Appeal judgment.
Correct.
But it says judgments you have written.
Yeah. I think I'm not referring to my form, but I think subsequent to that, I quoted that case as a reported judgment, and I then included other judgments in subsequent forms, which are completed around September, if I'm not mistaken.
No, but I'm not asking you that. I'm asking you about the section where it says, list the judgments you have written, and
Yes,
the
yes.
first judgment is a judgment of the Supreme Court of Appeal.
Yeah. The reason why I noted that judgment is that although it was not written by me, I am the one who presided in the court of first instance, which was a regional court in Mohwase. And it was fortunately, the judgment I quoted there was written by our present CJ, basically. But I wrote the judgment, actually I didn't write it when I was in Mohwase, it was just an extempore judgment. And that is why I sometimes talk about extempore judgment. I am the one who presided in the court of first instance. So I might have committed a mistake when I put it under that particular column.
Yes.
But I am the one who started the matter.
That is one of the points made by the GCB, that even that judgment, you did not actually write it. It was extempore.
Yes.
Then there is also another judgment you've cited, which is the Palo judgment. It is also a Supreme Court of Appeal judgment.
Correct.
Reported in 1999.
Correct.
And then there is also another judgment, which is Zondi. It is a judgment of the full court written by Stradom J.
In subsequent forms, Commissioner, I wrote judge judgments as reported judgment because I was sitting in the court of first instance. In other words, I was showing how I understand the law and how I apply the law in the court of first instance. Then subsequent to that, they got reported. So originally, I dealt with those cases.
No, I don't think we understand each other. The Palo judgment, there is no judgment written by you at all.
And
whether first instance or not, and the citation you've given is a Supreme Court of Appeal judgment. The second judgment, the third judgment, S versus Zondi, is a judgment written by Stradom J, in which you sat as an assessor, you did not write anything.
Which one did I?
Let's take, yes, State versus Zondi, which is the third of the four judgments that you've claimed to have written.
Commissioner, I'm not. Maybe I don't quite understand because I'm saying
no, I think it's
these are cases I dealt with as a court of first instance. Now, the reason why I highlighted those cases is not strictly speaking about having written those judgments at that level. It's not about it. It was about the principles there, how I applied the principle, how I interpreted the facts, how I married the facts to the law. So and of course, this one of Monarium, for instance, where the judgment was written by our President Chair CJ. I quoted there for various reasons. Not only that I said there, not that I wrote it. I quoted it, I referred to it for various reasons. For instance, if you look at how I applied the evidence of a minor child, the delay in reporting, that is the reason why I remember back then, it was around 2004. We didn't even have the sexual offenses and
I understand, Mr. Mkhotsi. I think both of us are of the same position right now, that the three judgments were not written by you. And the judgment of S versus Zondi, which is where we were in the conversation, was written by Stradom J. You were an assessor.
Commissioner, I'm not so sure whether I understand you correctly, because the only time I acted as assessor, it's in Palo. It's in Palo, State versus Palo. That was around 1997, 1996.
Yes, but
where I sat with Friedman, with Judge President Friedman.
No, I accept that. You've corrected me. I confused Friedman with Stradom. Palo was where you are an assessor, and then S versus Zone was written by Stradom J.
Correct, JP. No, I fully understand with you. I fully agree with you. I fully agree that I did not write those judgments. And that's what I'm saying. If you remember well, Commissioner, at some point I said, because of the state affairs I found myself in, if I'm not appointed, it's fine, because I did a mistake. I was not in my sound and super senses. I've already alluded to it that there is somewhere I did mistakes because of what was going on in my mind. So
all right, that's
it's,
fine.
but it's not like these cases. Perhaps I never had anything to do with them. As I said there, as the court of first instance. So it's not like I took matter from somewhere and just placed them there. But I'm saying I am not perfect, and I'm saying I committed a mistake, and I apologized in writing, and I still want to apologize even now for those mistakes.
Yes, sir. Now, it was just to say, not necessarily because you've completed the wrong form. I don't think anyone can punish you for that if you've got a good explanation. But I'm saying even the information you've given in that form is actually false. Thank you. Unless you want to say something more on that.
Commissioner, if I may come in, not to promote the dialogue, I'm not so sure whether it's fair to say, when someone is saying it's false.
Yes, all right, it's inaccurate, let's put it that way.
Sorry?
We can say it's inaccurate, let's look for a neutral term.
It's inaccurate, Commissioner, it's fine.
Yes,
and I once more want to apologize. From the bottom of my heart, I once more apologize. And if I lose anything, I still want to repeat, it's fine, I did a mistake, it's fine.
Thank you.
Thank you, Chief Justice. Thank you, Chief Justice. Good afternoon, Mr. Mokgotsi.
Afternoon, Commissioner.
Mr. Mokgotsi, Commissioner Mukaichobe has just taken you through your old form. I want to take you through your new form, the one that you submitted in September.
All right.
And I just want to deal with this treatment of, for example, the Palo judgment.
Correct.
Now, if you look at paragraph 6.3 of your new form, you've told us that in Palo you were an assessor in that matter.
Correct.
So if you look at 6.3 of the new form, it's paginated page 7 of your new form.
Page 7. Yes, I'm there.
You see, in 6.3, the question is, which cases in which you have appeared would you regard as being the most significant and why? And there you list the Palo judgment. Do you see the difficulty, Mr. Mokgotsi?
In interpreting the word appeared.
Now, are you saying that because you were sitting as an assessor, to your mind, you were appearing in that matter?
Maybe I need to explain further as to what happened there and why I quoted it there. I was an assessor, but what would happen there is that when the matter was set down for quite a number of days, weeks, if I'm not mistaken, as an assessor, we would be assigned to do a research if the role falls flat for that particular date. We were assigned to research, and we would use the court's library to research and to sit down with the presiding officer and participate in how the structure should be. Remember, we were called upon as magistrates. We were called upon because we had knowledge to a certain level of law and what was relevant and necessary. So I participated in deliberations. Maybe I may be faulted for having written it under appear, but I actively participated in deliberations. We sat down and discussed the judgment together.
Thank you, Mr. Mkhotsi. Can I ask, in relation to the cases which you've listed in 6.3,
6.3.
in which of those cases did you appear as a representative of one of the parties?
Yes, I think appearing would have been of course, it would also be incorrect to you to have written it under appear.
I'm sorry, Mr. Mkhotsi, you'll have to speak a bit louder. I can't hear you.
I would say it would be wrong to have classified them under this heading of appear, because these are cases I presided over. So I think I classified, I put them under the wrong heading.
I see, Mr. Mkhotsi, I must put a different concern to you. I've heard your explanation around why you completed the incorrect form, and I must extend my condolences to you on the loss of your late mother. The difficulty I have, though, is that you've adopted a methodology of just putting in a new form and asking us to disregard the old one. In circumstances where the deadline for the submission of applications passed, the applications were laid open for inspection for a very specific reason, so that we could get input from law bodies, from the public, on the content of your application. And through this procedure that you've used, you've actually undermined that entire process, because now you left us in a position where we don't have the benefit of the views of all the law bodies, the public, etc., on the content of your application.
Yes. Commissioner, I fully agree with you that I could not properly be evaluated because of that mistake. I fully agree with you that it's a mistake. I've already alluded to. It's a mistake I wanted to draw attention to. I fully agree. And that's why I'm saying, even if I don't make it, it's fine. But because I did not do that intentionally. I really did not do that. I can't go all out of my way to for instance, to write wrong cases under a wrong heading. I can't go all out and say I want to do this. So I'm accountable. I'm taking responsibility for that, and the fact that I could not be fully evaluated. Because, like I said, I spent 36, 37 years. I've written a lot of judgments. I could have put here a lot of cases here if I had that opportunity. So I'm saying I accept it. I'm saying I apologize for that. I'm saying
Where does that leave this body then, Advocate Mkhotsi? Do you accept that you've put us in a position where we are not in a position to conduct an accurate assessment of your competence, your capability as a judge? Do you accept that?
CJ, I'm accepting it because I see it keeps on coming, but I tried to amend the form. I sent a list of other cases which...
No, you've explained that a few times now. We have to look at the bottom line, which is that we do not have all the information we could have had you completed the correct form. We do not have all the information that is necessary to conduct a fair assessment of your capability as a judge. And I want you, as a judicial officer of long standing, to advise this body what it should do in the circumstances.
Thank you, CJ. Thank you so much. After my attention was drawn to this fact, I then amended the form. And I was quite surprised when I realized that it is said that my judgments cannot be found on SAFLI. I went to SAFLI and I found my other judgments. So the fact that there was reference to SAFLI, and I later on amended the form, I later on drew a list of about 9, 10 cases. I thought those kind of cases will be reached on safely, and I thought, I've all along been thinking that members of the commission went through those cases, and therefore they are able to assess me at least on the cases which are appearing on safely, and those I wrote as a supplement to the original form. So I thought my assessment would be based on that. But all what I'm saying now is that for 38 years or so, there are so many cases, other than the 10 I've included here. I have hundreds of cases which I could have included. But I thought this 10 would be enough to can evaluate me.
Are you satisfied, Commissioner Pillay?
And if I may go back and substantiate, CJ, I'm sorry to come in when I'm not invited to do so.
Yeah, go ahead.
Of the reported case which I wrote under a wrong heading, there is clearly stipulated how I applied the law. And if you look at, I think it's paragraph 12 or 13 of the judgment, which was written by your good self, there is somewhere where you assess me and where the Chief Justice is pointing out the mistakes I have done. So the reason why I wrote those kind of cases was sort of to give a balance to this commission, to say, although I have this kind of CV, there is somewhere around 2004 where I committed mistakes and which were picked up by the Chief Justice now, by you. So to give a fair balance that there was somewhere where I was committing mistakes, but at least in that particular judgment, for instance, I included it to say, look, subsequent to that, we have section 59 of the Sexual Offences and Related Matters, which I foresaw back then. I was just working on common law, but I worked on that to accept evidence of a minor child to convict. And I thought the list of cases I've submitted, the list of cases which are on safely, are able to show this honorable commission that I don't convict where I'm supposed to acquit. And I'm also not acquitting where I'm supposed to convict. And that is borne out by the fact that of all the cases I have done for all these years, no cases could be found on safely where my judgment was set aside. No case at all. So because there is no case which could be found on safely, I could only off my head remember one case where my judgment was and it could be somewhere in 2013, where my conviction was set aside. And there my mistake was this, that instead of swearing in a child, I was just from the High Court, I asked the interpreter to swear in the child. And on that basis, the conviction was then set aside to say I ought to have been the one who could have sworn in the child. But other than that, I don't have cases which were set aside, convictions or sentences which were set aside. And even if commissioners can go to SAFLI now, I'm not aware. I don't think they'll find any cases which were set aside because I convicted wrongly or I acquitted wrongly. Ever since, I don't think they'll find one. So on the basis of that, I think that issue would adequately address my competency, would adequately address my efficiency, would adequately address my independence. In other words, those three aspects would then ultimately allay the fear of me being appointed in Mpumalanga where I never acted. Because the judgments can show that I can act efficiently, I don't have any party matter, I can act competently, I can act efficiently, because I don't have a party matter, I don't have a matter which was set aside. I've been trying my level best to, even the sentence. You look at HEPL, for instance, the Northern Law Society of Provinces versus HEPL. The sanction, it was an appeal matter, the sanction I wrote there. It went on appeal in Bloemfontein, in Bloemfontein also, it was also confirmed, which shows that I can even apply a proportional sentence to the merits of the case before me. So I thought these cases were somehow, will be somehow place me in a position where I can be assessed. But where I committed a mistake, Chief Justice, I once more want to apologize.
No, we've already covered that ground. Thank you, Mr. Nkhosi. Any further questions, colleagues? No? All right. We've reached the end of your interview then. Thank you for making yourself available. You're excused. Phahla Muhlaka.
Good afternoon, Chief Justice, and good afternoon to the esteemed commissioners present here.
Did I pronounce your name correctly?
Perfectly correct, Chief Justice.
I'm happy. How are you?
Nervous, but I'm here. I'll be fine.
All right, that's the spirit. We apologize for keeping you waiting. We ran behind schedule.
No problems, Chief Justice.
You have 2 law degrees acquired from the university, from TEF, as we called it in its heyday, now the University of Limpopo.
True, Chief Justice.
Right. Between 1994 and 2014, you worked in the civil service. First as a public prosecutor, then regional court prosecutor, then state advocate, and switched over to the magistracy, district magistrate for 10 years. Were you a district magistrate for 10 years?
True, Chief Justice.
And then acting regional court magistrate for 4.
Indeed so, Chief Justice.
Right. Then you decided to join the bar.
Indeed so, Chief Justice.
Which one?
I started off on my own, and later I joined the National Bar Council of South Africa.
When exactly?
It could be around 2019.
All right. What do you mean you started off on your own? Were you
I was not a member of the bar. I was just an independent.
All right. So since 2019, you've been a member of which bar?
National Bar Council of South Africa.
And you are a member of the SAC IWJ.
Indeed so, Chief Justice.
Not many of your ilk associated want to be associated with that association. So I recognize that, and I must say I'm pleased by that.
Thank you, Chief Justice.
You have acted as a judge. You've had a number of stints, but very short. When you add all these stints, what do they come up to? And they start in October 2020?
They come up to 124 weeks, Chief Justice.
Sorry, how many?
124 weeks, Chief Justice.
All right. And you've acted both in Gauteng and in this court to which you seek appointment, Mpumalanga.
True, Chief Justice.
Right. Your last acting stint was in the second term?
My last acting stint was the last term that we are from, and I did even act during the recent recess duty.
In Mpumalanga?
In Mpumalanga.
All right. And I see that you've written judgments during your foray into the judicial field.
Yes, I have.
How many?
I've counted about 95 written and about 15 or so extempore.
Any of them reported?
No, only on Safely, Chief Justice.
All right. You listed 4 reserve judgments in your questionnaire. Are they still outstanding?
No, Chief Justice. They have all since been delivered.
Okay. JP Mpahle, do you have any questions for this candidate?
Thank you, Chief Justice, and good afternoon, Advocate Phahla Muhlaka.
Good afternoon, JP.
I noted you said you don't have any reserve judgment.
No, I said those that were reserved when I filled in the questionnaire have all been reserved. But since I was acting during the last term from September from August until now, from July, sorry, until September. I have about 3 reserve judgments. They are criminal appeal judgments where I am the scribe. So they are less than a month or so.
Okay. Thank you. And any partly heard matters?
Yes, I do have one partly heard matter because I was in the criminal court. I say one because the other 2 I have postponed them for judgment because sorry, and therefore I would not call them or say they are partly heard matters.
Okay. Thank you. If you can share with us your experience of the Middelburg Code.
My experience in Middelburg Court, the infrastructurally, the court itself, it's an old, it's housed in an old house where there's no privacy, for lack of a better word, because when you get out of your chamber, you go to court, you would encounter members of the public, some of whom are going to appear before you, and it is not a good thing for a judge to be in that kind of a situation. But in terms of work, Mpumalanga is a vast province, and work there, we are exposed to a variety of legal work and aspects of the law. One would have preferred maybe or recommend that a nicer building can be erected for Middelburg, because if you go there, many people get lost when they go to Middelburg High Court because it does not resemble a high court. But having said that, the experience is quite good. I've experienced people who are dedicated despite the shortcomings, and I cherish the experience I had in Mpumalanga.
So if appointed, you are willing to work under those circumstances. In essence, you are not going to make unreasonable demands.
JP, I've worked under those circumstances, and I made it my home. It is not the first time that I work under those circumstances. When I was a magistrate back then, in around 2003, I worked in a prefab as a magistrate for more than a year because the court at Edenvale, a branch of Jamestown Magistrates Court, was being revamped. It was a small prefab, and you would encounter the accused there in that court. You would sit just next to them and deal with cases. I was willing to do that then, and even now, I'm still willing to do that. I've made Mpumalanga my home.
Okay. Thank you. And in terms of the type of work that you're exposed to when you acted in Gauteng and Mpumalanga, if you can just share with us in a nutshell.
More or less similar, but in Mpumalanga, you have a rural communities which are not there in Gauteng. So you would have litigants fighting for land and so on. But besides that, you have a mining community in Mpumalanga, and you deal with many cases of be it urgent applications, as well as sequestrations and so on. So the experience in Mpumalanga is quite appealing.
Maybe lastly, just for the record, have you ever been subjected to any disciplinary proceeding by any regulatory body?
No, JP. Even now, I'm serving in the disciplinary committee of the Legal Practice Council.
Thank you, CJ.
Thank you, JP Premier.
Yeah, thanks, CJ, and greetings to KF Pasla Moshaka. I hope
Greetings to
that
you.
I am pronouncing your name properly.
You did, Premier.
Okay. It seems as if you know Mpumalanga very well, the vastness of Mpumalanga. Mpumalanga is more rural, and you know as such that sometimes people to have access to justice sometimes is very difficult. I want you to explain your understanding of access to justice for all. What are the challenges, and what is it that you think that we can do to address this challenge?
Thank you, Premier. As I said, Mpumalanga is a vast province geographically. And you have so many communities that are indigent. And when one talks to access to justice, the most affected are the poorest of the poor. And I'm happy that the JP of Mpumalanga has opened circuit courts for criminal cases. And because I grew up in a place called Denelton, as you can remember, at some point it was part of Mpumalanga. So I'm part of Mpumalanga in a way. And you have places like Marapian, places like Bushbuckridge, where you don't have the luxury of people accessing, more especially the civil court. So my contribution, because the only contribution that one can make, should I be recommended and ultimately appointed, is to engage with the JP to say, JP, will it not be feasible to extend the civil courts even to those rural areas? Because sometimes we tend to think that access to justice only is in relation to criminal matters, and we are wrong, because even on civil matters, you've got people's constitutional rights that are being affected, and because of their indigency, most of them are unable to access courts. Yeah, that will be my contribution. Should I be recommended?
I know that already you have indicated that if you are appointed, you are going to consider so deeply the infrastructure. That's what you said. Beside the infrastructure, what will be also your other priority areas?
My priority areas would be what I've already said, to go out there to the people, to serve the people, to to ask the JP and to agree to her giving us work at those areas, and I'll very much be prepared to work in those areas.
No, thanks, Chief Justice.
Thank you, Premier. Minister?
Thank you very much, CJ. Good afternoon, Advocate Patlamhlak.
Good afternoon, Minister.
How are you?
I'm trying.
Under the circumstances.
Under the circumstances.
Yeah. I looked at your CV. You have attended courses, training courses that I've taken particular interest in. You included training, including workshops, and you've been Commissioner for Child Welfare, Promotion of Equality, Prevention from Harassment Act, and Domestic Violence Act, which are quite interesting as from our portfolio trying to rebuild or to build a victim-centered justice system, especially within our courts, but also in terms of support. In an area or in a country that we have quite a lot of issues that we are dealing with in terms of gender-based violence. So I see that here, as you have done this work, perhaps are you able to share with us in terms of the work that you have done? And I'm noting that you've been a magistrate, though I note that you have exited. Perhaps that's one of the issues I would want to know. Why did you exit magistracy? But also the issue around what are the areas that we should be able to pay attention to ensure that we deal with issues that are faced by women and children, especially in gender-based violence cases?
Minister, first, I left the magistracy because I wanted to gain High Court civil experience. On the issues of what interventions can be made, we have statutes, very progressive. We have the Constitution that protects women and children against the scourge of gender-based violence. However, it looks like the country is not winning. And we need to reflect as a society to ask ourselves, where do we go wrong? And this, according to me, it needs our individual attention. As an individual, what do you do in your little corner, in your society, to try and deal with this scourge? Because it is just going out of hand. Besides the judgments, because the courts are at the last end of the tail, you would give sentences of life imprisonment to those who are accused of those. But as a society, what do we do? And if you check on my questionnaire, I am a member of the Phahla community, Phahla Traditional Council community. My focus there is to workshop our communities, our rural communities, about this scourge of gender-based violence. Because we cannot sit here and deny that these acts of gender-based violence are perpetrated mostly by men. And the question is, why does a 22-year-old who was born after democracy was attained still commits those acts? What are we as the community doing? What contribution do I make as a person who is alive to those issues? How can I teach my community or young boys that women are not the objects, but they are our equal. Because if we don't start with the young ones, this thing will recur because um, because of the social media, they look at the things and some may have interest in those and want to copy them. So my contribution would be, aside from the court work, one has to contribute and participate in their communities and use um, the, the, the knowledge we have to, to educate those communities. And if, as I said, if we start them at a young age, when they grow up, they will be having that knowledge that we are all equal, irrespective of our sex.
Thank you. Thank you, Sija.
Thank you, Minister. Commissioner Mpumalanga.
Thank you, CJ. Good afternoon, Advocate.
Good afternoon, Commissioner.
So just one area from my side relating to Baloyi versus Minister of Police as part of your contribution to jurisprudence. Baloyi versus the Minister of Police. And also thanks for affirming the Fees Must Fall Brigades strides on that particular day when they were attacked. But what I don't find in the judgment is the emphasis on the freedom of assembly, the right to picket, the right to protest. It's more putting more emphasis on what was probable and what was not probable from the versions of both the plaintiff and the defendant. Thank you.
I agree with you, Commissioner. Perhaps I should have added that, but I dealt with the facts that were before me. The Minister of Police being sued for unlawfully injuring the plaintiff. But I take note of that, Commissioner.
Thank you, Advocate. Thank you, CJ.
Thank you. Commissioner Baloyi.
Thank you, CJ. Good afternoon, Mr. Patlamhla.
Good afternoon, Commissioner.
Yes. It's about one of your judgments in Mpumalanga. Now, and I want to start this way, that there is the basic and tried principle that no one should be subjected to an adverse order without being afforded a hearing. You accept that? You know that principle?
I do.
And it has been described as a sacrosanct principle of our law.
Yes.
But in addition to that, there is also the principle of precedent, that judgments or authorities of higher courts are binding on lower courts, right? You accept that?
True, Commissioner.
All right. Now, you, in the matter of, you've referred and you've given us a copy of your judgment in Mpumalanga versus the state, and it came to you, it was a bail matter. Do you remember that matter?
Yes, I do.
And there was an issue about whether it's a review or it's an appeal. It was brought to you, or at least the case pleaded was a review. And then when they came before you, it turned out that, in fact, they're pursuing an appeal from the magistrate's court. Am I characterizing it correctly?
Indeed, so although they were not sure what course of action were they before me on.
Yes. Now, then you make the decision that you make, and then it comes to a question of costs. And you granted an adverse order against the legal representatives of the applicant. And in particular, you said they would forfeit fees. They were not to recover any fees from their client. Do you remember that?
I do,
Now,
Commissioner.
in the judgment, nowhere does it reflect that you afforded them a hearing before you made that adverse order. Now, this is a judgment in January 2025. I have mentioned to you the tried principle, but also there is a judgment of 2021 of the SCA which deals with the matter, which dealt with a similar matter where legal representatives had been refused, had been ordered that they wouldn't recover their fees. And the SCA merely reiterated the principle of law that we know. Did you not inform yourself on this topic, what the authorities are? Did you not remind yourself of this tried principle that they should be granted a hearing before you made such a serious order against the legal representatives?
I did, Commissioner, and I'm just trying to browse through, but I remember I asked counsel to address me on that aspect, and I asked him why should the client be left out of pocket as a result of your shoddy work, as a result of a bad advice, and in a sense he agreed with me. I know the precedent that you ought to afford them an opportunity. In my view, I afforded him an opportunity to address me, and that is how I found the way I found.
Well, the judgment in your bundle of documents is at it starts at page 36. Nowhere in your judgment is there any reflection that you invited the legal representatives to address you. But even if you had, in that hearing, I would still raise the question with whether you gave them reasonable notice, because you are required to give them reasonable notice to make submissions on this topic. But that judgment doesn't reflect anything that suggests that that speaks to what you've just said now.
I agree with you, Commissioner.
It doesn't record that.
I agree with you,
and so it is fair for me to conclude that you in fact did not give them the opportunity to address you if it's not in your judgment.
Yeah, it is fair. It is fair, Commissioner.
Okay, thank you. Thank you, CJ.
Commissioner Jivan?
Sorry, that's just a follow-up, Councillor, on Advocate Sese's question. Perhaps she missed paragraph 13 of the judgment. Mr. Advocate Mpumalanga, maybe you want to look at number 13 of your judgment. If you want, I can read it.
Yes, Commissioner. Thank you, Commissioner.
The applicant's counsel concede that the applicant should not be left out of pocket as a result of the wrongs of his legal representatives. I agree that this is a classical case where the legal representatives of the applicant should not be entitled to fees, and if the applicant has paid these fees, must be refunded. Has paid those fees must be refunded. Thank you.
Thank you, Commissioner. I was just browsing through quickly. I remember I had that in my judgment, but thank you.
CJ, if I may, on this. What do you understand? I've raised two things with you. I've said to you, you didn't give them the opportunity, doesn't reflect, and I also said you have to give them reasonable notice to address you. What do you understand to be the obligation of a judge who is confronted with a matter where they form the view that counsel or even the attorney should not be allowed to recover costs, or they should be marked even with cause de bonis? What do you understand to be the obligation of a judge in those circumstances vis-a-vis that legal representative? And do you consider yourself, if this is all that happened here, do you consider this to have been adequate, notwithstanding what the SCA has said in the matter of Chiti in Re Lufuini Mkunu community versus Lawrence Hancock. You don't regard that as binding on you, where it directs you what you should do.
I have already considered that. I agree with you, Commissioner.
Thank you.
Yes.
And insofar I didn't mention that paragraph that my commissioner has referred to. I didn't mean to mislead you in any way, and I do apologize for that. Thank you, CJ.
Prof?
Thank you very much, CJ. Good afternoon.
Good afternoon, Commissioner.
Can I please take you to page 16 of your document? Hand paginated page 16. I wouldn't know if what page number would be on, or page 11. This page 11 on the one that you did. Anyway, for the sake of time, in that particular page, you list your cases that have been overturned on appeal.
Yes, Commissioner.
And one of them is Steinhoff International Holdings versus Competition Commission of South Africa.
Yes, Commissioner.
Yes. I'm not sure. Have you had chance to look at the judgment of the full court in this case that
Yes,
overturned you?
Yes, I have.
Because it was quite concerning for me when I was looking at that particular judgment, and in particular, paragraph 30 of that judgment, where the court seems to be of the appeal court, the full court seems to be of the view that in your judgment, one, you fail to give reasons, but secondly, you fail to address some of the, or three of the most important allegations that were made before you. I'm not sure if you have seen that.
Yes, I did.
I'm not sure, do you have any comment on that? Was that a fair reflection of what you did in your judgment?
It was. And remember, it was, I think, in 2021 when I had just started acting then. And on reflection, I agree with the full court.
Okay. My second question then would be, sitting as a judge of the High Court, you will from time to time get applications for leave to appeal to that court. I am interested in the test that needs to be made for one to be successful in such an application. Do you have any comment on that?
The test is whether the appeal has a reasonable prospect of success. Or that there is or there are aspects of the law that need to be ventilated on appeal.
Is that the test?
Yes.
Oh, okay, let me leave it there. Thank you very much, TJ.
Commissioner Hassan, then JP Tlalitsi.
Thank you very much, Chief Justice. Advocate Commissioner Hassan over here.
Thank you, Commissioner.
I thought maybe it's important to mention that I was in fact present on the 23rd of October 2015 at the Union buildings, and I was one of the students who were running away from those bullets that you made a decision on some years later. In fact, next week will be 10 years since the occurrence of Fees Must Fall. So I thought I'll mention that on a side note. And also on a side note, appreciate the outcome of your case, of course, as a student and a student leader at that time. But my question is a little bit different to this. Advocate, one of the law bodies noted that your courtroom temperament or rather they appreciated how you were fair and that you were widely admired, but that your exposure to complex civil matters could be broader. I think the Middleburg Legal Association said this. How do you respond to their concern?
Thank you, Commissioner. Commissioner, I've got a vast civil court experience. I've acted for about 124 weeks. I think 70 or so of them in the civil section. I note their concern, but I beg to differ with them. However, they are saying I need more acting exposure. I don't agree. I'm of the view that I've acquitted myself and I'm ready to assume a permanent position. Thank you.
No, thank you, CJ. I'm glad that's been clarified. Thank you.
JP Tlalesi?
Thank you, CJ. Actually, that was the question I was going to ask. But then the follow-up to it would be the Middleburg legal practitioners at paragraph 5, they provide the reason why they say you would need some time. Would you say they are being malicious to you or what? Thank you.
JP Tlalesi, I won't say they are malicious. That's their view. And I don't agree with it, but they are practitioners and legal practitioners or lawyers don't always agree on issues. So I note their concern and I respect that, but I don't agree with it.
So, but we never had difficulties with them that could have prompted them to come up with this situation.
They are saying I acquit myself well in court. I'm just trying to look for the relevant section. But what they are saying is that I lack civil court experience, and they are basing it on the fact that some of my judgments have been overturned on appeal. And in my view, that cannot be the criteria. Thank you.
Thank you.
Commissioner Mkalcho?
Thank you, Chief Justice. Good afternoon, Advocate Patlamuhlaga.
Good afternoon, Commissioner Mkalcho.
I will not say anything about the Steinhoff case, given that I'm the counsel who appeared before you on behalf of the Commission, and I only won the case on appeal.
Yes. It's true, Commissioner Mkalcho.
I just want to ask you about the objection by the attorneys in relation to your conception of urgency in the ESCOM case. I think it's Tsepo Musaka, if I'm not mistaken. You remember that?
Yes, in fact, it is the litigants.
Yes. Now, the substance of it is this. On the 25th of September 2024, sheriff came to evict a group of people that lived on ESCOM properties. You remember that?
Yes.
On the same day, they approached you for an urgent interdict. But you stood down the matter to the following day, where you struck it from the roll. You remember that?
Yes.
Now, they say that the fact that you stood down an urgent application in the course of being executed shows that you have no conception of how the right to housing interfaces with urgency under Rule 612. What is your response to that?
I do not agree, Commissioner Ngugaitobi. This matter has got a history. That was not, according to their own founding affidavit, that was not the first time they approached a court on that particular matter. They they appeared, they approached the court, were heard by Manghe J. She ordered that the respondent be served. And after the respondent was served, that was, I think, in July, the matter was struck off the roll. So it has a long history, and if you look at my judgment, that's why I said they could have approached the court for the stay of execution, and they
I think we misunderstand each other. I'm not quibbling with the outcome, which was delivered the following day.
Yes.
Because I think it's unfair for the commission to look back and say you should have given a different outcome. What they are saying is that you stood down an urgent application in the course of being executed, which meant that if you gave your judgment a day later, it would have been Brutum Fulman. The sheriff would have finished the execution.
I did that, and I had to consider the facts. I could not just give judgment without considering the facts. That's what I did.
Yes, but I still don't understand what I suppose it comes back to this thing about being sufficiently experienced to dispense decisions on urgent applications, because it seems their concern really is, why are you standing it down? If you're going to strike it now. If you're going to grant it now, so that the sheriff can stop, because the sheriff is currently executing.
That's my answer. I considered the history of the matter, and I had to consider the facts. I didn't just want to give judgment there and there.
Yes, thank you. And then, what have you learned out of it, if anything, given what they are saying? I just want to understand if a new urgent application came in the course of being executed. This is not a typical urgent. It's currently being enforced. If you say you will apply the same approach again, you will say come back tomorrow, or you will actually decide it. Either way.
It will depend on the facts then. I may have to consider giving judgment even if it's midnight, because it does not say that when you are faced with those facts, with the history of this matter, you just there and then give judgment because without having considered the facts. Maybe I should have delivered judgment midnight or early hours of the morning. Thank you.
Certainly earlier than telling them to come back the following day.
Yes, maybe on hindsight I should have done that.
Thank you.
Anyone else, colleagues? Advocate Patla Muhlake, you're excused.
Thank you, Chief Justice, and thank you to the esteemed commissioners.
Shall we clear the room, please?